May I have your lordships kindly to mention approval in the commercial division, my lord, for listing. My lord, there's some urgency. If it could be
Listing before vacation, it will be listed,
it is
Mr.
only for interim relief. My lord, my section 9.
Anyway, it will be listed. Give it.
Well, it could be listed on Monday or something. It's grateful.
Who is this? No, virtual mentioning is after physical mentioning.
Milord, I'm saying that Mr. Bose that it's reverberating. There's some technical lag on the.
Mentioning. Yes.
Milord, matter settled, my lord, for withdrawal, my lord. If your lordship may consider keeping it for withdrawal, my lord, the case is settled.
To be mentioned tomorrow?
Yes, my lord. Yes, grateful.
My lord, appeal, my lord, extreme urgency. Request, my lord, your lordship can consider any date, my lord, next week.
It will be listed?
Well, I'm grateful, my lord.
My lord,
May it please your lordship, my lord, may I have your lordship's kind leave to mention this appeal for inclusion, my lord?
Give it
My lord,
inclusion.
there is some urgency, my lord, if it can be
Which
taken.
matter is not urgent, sir? Indicate any matter in the list which is not urgent. We'll delist it.
If I may only take 30 seconds of your lordship's time.
No. Yes.
May I have the kind leave to mention this matter? The main suit was dismissed for default on February 2nd, 2024, and an instant appeal regarding that suit has been filed and has been running in the list.
Appeal from an order dismissing the suit for default.
And it was dismissed on 2024 February 2nd.
No restoration application was made.
Your lordship, and also the defendants had died. It's more than 90 days they have died.
You want listing of the appeal? What do you want?
I am praying for dismissal of the said appeal, your lordship.
Or for the respondent?
I'm for the respondent number 8 and 9, your lordship.
Dismiss for default. You are not suffering any interim order, are you?
No, your lordship.
No. Very well. We'll see. Call the list.
Grateful, your lordship.
But I pay for the state. No, Nama. I'm very worried. My counsel has forgotten not for whom he's. Come down. Look, this note.
There's a.
Yes, Lord, I understand there's a decision of the Honorable Supreme Court, my lord. So, Lord, immediately after we
4 months. Only thing. Are you sure I have nothing to do with this matter?
No, your lordship.
When I was in practice.
No, your lordship has nothing. No, nothing.
One Rajpath, I was an arbitrator.
There is nothing to do. Lord, he's always been a
Lord, I appear for the appellate.
Yes.
Lord, to the best of my knowledge, my lord, Justice Banerjee had no involvement in this matter.
Very well. When should we keep it?
But immediately after vacation.
Immediately after the vacation. Order of the Supreme Court is dated
8th August, 6th August.
6th August, September, October, November, December. I see. Immediately after.
Enough.
Reopening day?
Yes.
No,
Yes, that's the best day.
Mr. Advocate, reopening day?
Yes.
Or not 2 days. I'm not.
Reopening day, there'll be nobody around.
Yes.
You can...
But he won't also be there. But I'm sure he won't also be there. Lord.
Following Monday, তাহলে ওই 27 তারিখ বোধহয়।
Yes. হ্যাঁ ঠিকই আছে তো immediately to 24
আমার এনসিএলটি যাব দাদা আমি থাকবো না
আচ্ছা
Ms. Banerjee, please consider our position also. Direction from the Supreme Court.
Lord, 27th Lord is Monday. Your lordship takes Lord non-commercial on Tuesday. So Lord 28th Lord will probably
28.
Yes.
20.
I'm grateful, man.
Yes.
তারপরে নেন টিউসডে আর ওয়েডনেসডে নেন সেই জন্য বলছি টিউসডেটা হ্যাঁ ও বাবা অতি বাট ও তো সেন্সিস আরে বলো না তাহলে I'm sorry, Lord, 29th, Lord.
Let it be on the 28th because if the appellate side list
collapses, then it will
is exhausted or collapses.
Grateful to Lordship. Lord, I appear not for the special officer. Lord, your lordship had discharged not the special officer and appointed another special officer, Lord, who had expressed his difficulty, Lord, in acting. Lord, thereafter, Lord, we had mentioned for change of personnel.
My lord, my lord, my lord, Lord, in the previous matter, my lord, if an order could be recorded, my lord, that is.
Since there is a direction of the Honorable Supreme Court to try and dispose of this matter within 6 months from the date of the order of the Honorable Supreme Court, which is August 6, 2025, let this matter be listed under the heading specially fixed matter immediately on October 28, 2025.
Would you have my lord's pleasure to record that this was communicated to the registry today, my lord? Because I think, Lord, a month later, my lord, it has been communicated to your lordship. Lord, I think
Paragraph.
it will probably not be in.
I've got filed it.
Yes, my lord. I think it.
Although it was communicated by the registry, but I had mentioned this. Whatever it is, I have.
We
notice
put it on record that the order of the Honorable Supreme Court was communicated when, Mr. Simha?
Lord, I think Lord, yesterday, your lordship has been. Lord, day before yesterday, my lord, it has, I think.
Yesterday, next October.
Okay. My lord, whenever the registry has communicated to your lordship, my lord,
Supreme Court জানিয়েছে put on record that Supreme Court was communicated to the registry of this court on September 4. Received. September 4, 2025, and our registry communicated the order to us on September 8, 2025. আচ্ছা ওটা রেজিস্ট্রি না করে রেজিস্টার অরিজিনাল সাইট বলবে সব জায়গাতেই রেজিস্টার অরিজিনাল সাইট Yes, 3 and 4.
Yes, so my lord,
But I am for the official liquidator.
my lord, this was only for the change, my lord, as far as our prayer, it's only for the change of the personnel of the special officer. My lord, thereafter, my lord, an application has been filed by my lord, the
Company in liquidation.
We have the company in liquidation, my lord, praying for my lord, certain direction.
Saying that it has come out of liquidation.
Lord, as please, there is no direct, but I could not find any order, Lord, that there is the company has come out of the winding up. And Lord, the other thing, Lord, the official liquidator has filed a report note indicating that various creditors, Lord, are entitled to, Lord, sums of money, Lord, which is being adjudicated, Lord, by the landed single judge.
Mr. Mitro, we were not inclined to take up this matter.
No. That was decided. That was in the other matter, my lord. Your lordship.
No, even this. We only have kept this matter just for change of personnel of receiver.
For the time being, very well.
Otherwise, we are not entering this application that you filed. It may be heard.
I have not filed, my lord.
I have filed. I am for the company in liquidation.
I am the appellate.
Oh,
So I am the company
that
in
will be
liquidation.
heard by some other bench.
Very
to
well.
whom it will be assigned.
This is, kindly don't take me amiss, my lord. This is exactly what, my lord, was prayed for by someone, my lord, about a month back. I opposed, I said that, my lord, your lordship, my lord, Justice Banerjee had nothing to do with this matters. Now, my lord, the person who mentioned it, my lord, a direction was given that you file an affidavit. Possibly it was not recorded in any order. But, my lord, an observation was made that you file an affidavit.
Recorded in order. There was an order.
Recorded in order. Oh, very well. Now, the affidavit has not come. Now, my lord, in this manner, my lord, this, in my respectful submission, should not be encouraged, my lord.
Mr. Mitro, we do not
They are
really
asking that even now.
No, we don't want to take it up. But only because Mr. Dev is seriously ill, we have kept it for the change of personnel. Now Mr. Ghosh has recused himself.
My lord, in fact, my lord, we requested my lord, him to suggest somebody, my lord, who will be willing to, he suggested Mr. Manish Roy, my lord, Bar Library Club, my lord, if he could be appointed.
We can appoint him.
Lordship.
Issue.
Lordship, just
And my lord,
one-
rest your lordship should, my lord, decide later on, my lord. Rest. This part, yes. Let us do it in parts.
We will not take it up.
Very well, my lord. Lordship should decide that, my lord.
May I only
What?
May only indicate one thing, the official liquidator has filed a report. I am ready with my exception. Your Lordship may substitute the learned special officer. I have no objection in this. Your Lordship may kindly take my exception on record. That's all. To the report of the official liquidator.
Exception filed by the company in liquidation to the report of the official liquidator be retained with the records. Paragraph, we have kept this matter in our list only for the purpose of appointing a new special officer in the place of and stead of the present special officer who's not keeping good health, comma, we are told. Paragraph.
Lord, him lordship is already discharged by 15th May.
Oh, we have discharged already.
Mr. Deepak Dev already discharged.
Oh, sorry.
Shown in the court. Yes, ma'am.
Sorry. কি বললাম বলো?
15th May order.
In the place and stead of Mr. Shornendu Ghosh, comma, learned senior advocate,
Yes.
comma, whom we had appointed in the place and stead of Mr. Deepak Dev, comma, learned senior advocate, since he was not keeping good health. He has not been keeping good health. Paragraph, Mr. Ghosh has expressed his difficulty in acting as the special officer. Paragraph, accordingly, comma, as suggested from the bar, comma, Mr. Monish Roy,
My lord.
comma, learned advocate and member of the
Bar Library Club, Lord.
Bar Library Club, comma, Calcutta High Court, comma, is appointed as the special officer in the place and stead of Mr. Shornendu Ghosh on the same terms and conditions on which Mr. Ghosh was appointed. Paragraph, we were minded to release this matter from our list today itself. Stop. However, comma, Mr. Mithro, comma, learned senior advocate appearing for
The appellant.
the appellant says
Number 2.
says that decision could be taken on some other date. Appellant number 2 kore debe, huh? Paragraph, list this matter immediately after the samanna ki pujo vacation. It is same order in 3 and 4.
Yes,
Yes, Your
Combined.
Same order and
Combined order.
combined hocchilo. No, separate orders,
Very well, Lordship.
which is good for the profession.
Hopefully. Not anymore, Lord.
Hopefully.
Hardly anybody.
Hopefully.
Hardly anybody. Kind of ask for the cave that.
Grateful, Lordship.
Cave that.
Item number 5, I am appearing
for the
respondent, my lord. I am appearing with the respondent, my lord. I am
Yes.
playing time by after vacation. My lord.
Why?
Ognishwar Bhuiya is a serious ill.
Who?
Mr. Ognishwar Bhuiya is appearing in this matter.
Yes, what is your, this is an appeal against?
They filed an application for disbursement of the total security money, my lord.
Yes, because your appeal was dismissed for default.
Yes, my lord.
Yes.
They are restored, my lord.
It's restored
Today
already.
Yes. Restored. Today fixed for the.
Now the
hearing of
appeal has to be heard.
No, appeal has to be heard, and along with the application they filed that. Kindly allow me to file the evidence of opposition that against the application. They pay for the disbursement of the.
We are not disbursing. You need not file any opposition.
They have
Yeah,
filed the
here-
application. They have
Ore
filed the
Baba,
application.
we are not-
Fixed for
Just
hearing
one-
today.
তুই বলে দে একটু আফটার ভেকেশন চাইছি আফটার ভেকেশন করে দে করে দে। হ্যাঁ করে দে বল দে ও চাইছে অ্যাকোমোডেশন চাইছে
As prayed for on behalf of the respondent, comma, list this application immediately after reopening of the court after the ensuing puja vacations.
ওর শান্তির জন্য ইন দ্য মিন টাইম অ্যাপেলেন্ট উইল বি
Evidence of opposition.
Grateful.
application filed by the respondent.
In the meantime, the appellant shall be at liberty to use an affidavit in opposition to the application filed by the respondent seeking disbursement of the amount deposited by the appellant.
In court.
In court.
Yeah, cool.
Looking at my instance, my lord.
But I appear on behalf of the respondent number 14 and 15 led by Mr. Kaur, my lord.
That I think they had appeared on the last occasion also, and in principle, they don't have a problem. But this was a partition by meets and bounds. The report was also accepted, preliminary decree passed. After that, partition commissioner goes, report comes, report accepted. One issue that we have, there's a delay of 277 days. I'll tell you, Lordship, why. Because the the issue is that the partition commissioner has been appointed and directed to register the deeds in respect of each share, in respect of each of the parties. The property has been divided into 5 or 6 lots, 5 lots. Now that registration, your lordship will consider is not necessary anymore. So, and the other real issue that we are facing is that despite the partition
Registration of the preliminary decree.
of the final decree.
Oh, final decree has been
Final
passed.
decree has been passed. In the final decree, the direction that the partition commission will register the deeds in respect of each share, in respect of each of the lots.
Is it not necessary anymore under the law?
Under the law, my lord, it's not compulsory registrable.
Under the Registration Act, it's
No,
not.
but it's covered under 17. I may choose not to register it.
What you say will anyhow to everybody's benefit.
Yes,
Non-registration.
But the difficulty is, what is really happening is when I'm going to get the decree stamped, because the decree doesn't specify as so, I am being asked to pay the stamp duty on the entire property and not my share. So that is the real clarification that we seek from your lordship in appeal. Because under
that bit can be done.
that is the real issue.
The stamp should be proportionate to the share, the stamp duty. For every share, entire stamp duty cannot be claimed. And this is not, it's going to help you only, help everybody. Yes, which section you say?
17, Roman 6 and Roman 7, your lordship will consider. Section 17, subsection 2, Roman 6 and Roman 7. Sorry, Roman 7 and Roman 6 or 8. Any decree or order of court. Nothing in this clause B and C The problem with registration, my lord, that once the partition commissioner does the registry, every other person will also have to be a signatory to that deed. Because a deed of conveyance is not necessary. That B and C has been exempt. E might look problematic.
Yes, my lord.
E, your lordship will see, might seem problematic because subsection 2 excludes B and C. E might seem slightly problematic, but E is slightly different. Non-testamentary instruments.
That's transfer or assignment.
That's right, of a decree. I have a debt which I've gotten under decree, I'm assigning it, I have to register it. But any decree of order of court is exempt. And Lord, in just to add to this, well, probably a conveyance will not be necessary in respect of that's the whole point of the final decree, Lord. That decree attains finality, that is the deed. Separately, partition commissioner will execute a registered conveyance in favor of each party.
That's the instrument of partition, not a decree. Mutual partition to be filed. Mutual partition to be instrument, right? That will require registration. What will be partition decree possible? That will not. Would be the chair, I suppose.
Oh, please.
Stamp duty সেটা তো করিয়ে দেবে রেজিস্ট্রেশনটা কি করাবো everybody will sign stamp duty I
proposing the prayer.
My lord, Mr. Kaur has got some submissions to make, my lord. I've got no instructions about opposing it on the face of it, my lord. He has got some
Mr.
submissions.
Banerjee, let us also hear Mr. Kaur then. Mr. Anirban Kaur.
Yes, my lord. Mr. Kaur.
Where is he?
My lord, he is addressing presently code number 40, my lord.
Shall we pass it over?
Yes, my lord.
Or not today? What do you want? Tell us. You can have it on Friday.
Friday, my lord.
না এটা কি নন কমার্শিয়াল তাহলে তো ফ্রাইডে হবে না again next Wednesday
then you will pass it over, I'll come back, no?
See,
Time frame may be fixed, my lord, so that we can come back at a particular time, my lord.
কোর্টকে কি করে আমি ভাবতে চাইছি আমি বলবো টাইম ফিক্স করে দাও ঠিক আছে come back.
Item number 7. I appeal the appellate in this matter. Lordship, as per Lordship's last order, Lordship, since the defendant number 2 had passed away, Lordship had directed us to go for substitution, whether substitution would be necessary or not. Although we had filed an application and we had to withdraw because it was not in compliance with the original side. Lordship, today, Lordship, I am not willing to proceed with any substitution application. I want to proceed with the appeal itself. Lordship may kindly allow.
appeal will abate against the. Whether the appeal will abate against the respondent number 2 or his.
Because the entire claim is against the LLP. So, and the respondent number 2's heir, one of the son is already a member of the LLP now. So there will be no abatement as such.
दाओ कागज दाओ देखिए.
No, kindly, I'm not record the date of defendant number 2, respondent number 2. I'm not. May I come back with an affidavit in that case? There is no scope for interim order. There is no scope for interim order. The order impugned is, my lord, the court has not passed the decree as paid for them. Court has invited a report from department. There is no scope for interim order. Kindly give me
the order,
my lord.
Tiwari.
My lord.
Lordship, the impugned order is at page 13 of the statement.
MS Tiwari. MS Tiwari.
What is wrong with the order?
Lordship, if I may. Lordship, the suit is based, if I'll just surprise my lords with the facts of the case, Lordship. The suit is based on Order 37. Right, Lordship, it's a summary proceeding. An amount of the plaintiff had given a loan of 25 lakhs to the defendant on 11th of February 2019 with interest to be paid at 12% per annum. Lordship will kindly see the bank statement at page 34 of the stay application, Lordship.
Why shall we go into the merits of the claim?
Lordship, because until unless Lordship.
No, because there is no decree of the court as yet
Lordship,
dismissing your suit.
Lordship, but the last order of the division bench says that if the defendant does not secure the amount, then the suit shall proceed ex parte.
Yes, it will, subject to compliance with the other formalities.
Lordship, but
that is
Lordship
exactly
kindly
what the
see
learned
the
judge.
impugned order. Lordship will kindly see the impugned order
Madam,
once.
we have seen, we have just read the order.
Lordship, once. Lordship, kindly bear with me, Lordship, for once. At the first page of the impugned order, Lordship, it says the filing of the applications by the defendant gives a clear indication. It is already an observation of the court that the summons were served. And that is why they have appeared, they had filed an application for leave to enter appearance for condonation of delay and for that the suit comes under commercial division. So, Lordship, today the question of going back to the department for seeing whether the summons were in proper format or not does not arise.
They have not.
In my humble
two
submission,
formalities
Lordship.
there. They have not taken out a summons for judgment. Without taking out summons for judgment, they own decree.
It cannot
It
happen.
is mandatory.
No, it cannot. Lordship will kindly see.
And that is the observation of the honorable judge.
Lordship will kindly see order
35.
36 once.
Order 37, Rule 3, my lord.
Order 37.
Rule 3. No, 5. Kindly see 5. Sub rule 5. 3, 5. They have to take out a summons for judgment, which is yet to be taken out. Learned just wanted to verify from the department whether they have applied the formality. Against that, they have come to the appeal court.
My learned friend is skipping the clauses which is already stated there. Lordship will kindly see clause 4, subclause 4, Lordship. It says if the defendant enters an appearance, the plaintiff shall thereafter serve the defendant a summons for judgment.
Judgment, which is not
Only
taken.
after their appearance, they have not entered appearance in the suit itself.
I have entered appearance. I filed 2 applications. One
No,
seeking
never
conjunction of delay.
See page 66.
What she is talking is
Of
that is
the
the order
application.
recorded here.
Page 66 of my say application once.
Let her complete, then I'll address your lordship.
Page 66 Lordship has.
No, page 68 is the order.
Page 66.
I appeared out of time.
It says
I appeared but out of time.
It says at request of so-and-so advocate for the plaintiff in the above suit, I do hereby certify that the defendants have not entered appearance either in person or through advocate up to 11 a.m. of this day of 1st August of 2023. So they never entered appearance. Thereafter, when they have filed an application stating that they have entered appearance, Lordship, thereafter we have again caused a requisition to the department asking whether they have entered appearance or not. That appears at page 67. There it says, the defendants have not entered appearance either in person or through advocate up to 2:30 p.m. of this day of 29th day of September 2023. So they've never entered appearance in the suit. Today, they don't even have the right of audience. And until unless they enter appearance, I cannot file a summons for judgment. It is only after their entering appearance I can file a summons for judgment. Thereafter, they will file to a leave to defend. And even in the impugned order, Lordship, there is a observation of the learned judge where it says that the summons were already served upon them.
Madam,
Lordship.
the basic thing of advocacy is when the 2 judges are
I
discussing,
apologize, Lordship.
you allow them to discuss.
I apologize.
When did you enter appearance?
Not within 10 days, out of 10 days. I appeared thereafter, I filed an application.
No, you're filing application, Mr. Tiwari. Are you permitted to enter appearance after 10 days?
But I have kindly see or Rule 7. Order 37 Rule 7. 37 Rule 7 kindly see. Kindly see order 37 Rule 7. 37 Rule 3 Sub Rule 7.
Yes.
Court or judge may, for sufficient cause shown by defendant, excuse the delay of defendant in entering appearance or in applying for leave to defend. I have done so, and that was rejected by ex party in my absence. And she is shouting that I didn't ever appear.
No. So therefore,
I appeared. I filed an application for
Mr.
condoning
Tiwari,
delay.
the time to enter appearance
Expired.
has not been extended by the court.
Yes.
So therefore, you have not entered appearance. She's right there.
No, then Lord kindly see the appeal was preferred.
Point is different. Whether we shall interfere or not, we do not see how this is an appealable order, firstly. Even going by Kimji.
Even if I do not appear,
Yes.
but she is not entitled for expiry decree. I have a right to cross-examine the witness. When the court will hear the suit, ex parte, I have a right to cross-examine the witness. She cannot get the decree suo motu.
Who has denied you that right?
That what he's asking for, the decree ex parte,
No.
suo motu.
No. It has to be, it may be disposed of ex parte, but that's undefended, what you are saying.
Yes.
Undefended, if it appears, you have a right to cross-examine.
Yes.
Here, the court said if you don't deposit ex parte, the revision, the 30 lakhs, then the suit will be decided ex parte.
Ex parte.
Which means you are not allowed to participate. That is different from when a suit is heard as an undefended suit. There, the defendant, although has not filed written statement, has the right to cross-examine. But we are not on that. We are not on that.
If I may just submit certain.
Yes, in reply, what do you have to say?
The only thing is they were given an opportunity by the division bench to.
What has the learned judge decided, madam?
Lordship.
What right of yours has been decided?
Yes, Lordship. Lordship, as per the order, impugned order, Lordship will kindly see the finding of the learned judge was this, that the filing of the applications by the defendants gives a clear indication that the summons for suit in Form 4 of Appendix B, as required under Order 37, Rule 2, Sub Rule 2, with a copy of the plaint in terms of the said order, was served on the defendants. Was served.
When?
It is said it was served.
When?
Lordship, that has already been decided in the division bench's order, which is at page 72. Lordship will kindly see. It starts at page 72. Lordship will kindly.
So you want us to direct the learned judge to pass a decree in your favor?
Lordship, I am humbly only praying that
What?
if the Lordships can pass the decree, because the Lordships have the power to pass the decree in the matter.
Anything else? Anything
Lordship,
else?
Lordship, that is my humble submission.
Issue. This appeal is directed against, by consent of the parties. The appeal and the connected application are taken up for hearing together. This appeal is directed against an order dated April 21, 2025, passed by a learned judge of this court in CS 54 of 2023, being a suit filed by the appellant herein against the respondents. Stop. The suit has been filed under the provisions of Order 37, Roman 37 of the Code of Civil Procedure, 1908, bracket in short CPC, bracket close. Paragraph. It appears that the defendants in the suit did not enter appearance within the prescribed period of 10 days after the service of the summons. Stop. The defendants, however, filed an application for extension of time to enter appearance and also an application for rejection of the plaint under Order 7, Rule 11, CPC. Stop. Both the applications were dismissed by a learned judge by an order dated September 11, 2024. Stop. Paragraph. The order dated September 11, 2024 was carried in appeal by the defendants, being APOT 364 of 2024. Stop. A coordinate bench, while disposing of the appeal, granted an opportunity to the defendants to defend the suit, provided they deposit rupees 30 lakh with the registrar, original side within 3 weeks, within a prescribed period of time. Stop. In default, the division bench directed that the suit may be heard as an ex parte suit. Stop. Admittedly, the defendants failed to deposit the amount within the prescribed time period, amount of 30 lakh, amount of 30 lakh, prescribed time period. Stop. The defendants made an application, being GA2 of 2025, for extension of time to deposit the said amount. Stop. The division bench extended the time, the division bench by an order dated March 5, 2025, extended the time by 2 weeks, clarifying that in default, the suit shall be heard ex parte. Stop. Paragraph. When the matter appeared before the learned single judge, it was submitted on behalf of the plaintiff that since the defendants have not deposited any money in terms of the division bench order dated March 5, 2025, the suit should be heard ex parte. Stop. The plaintiff prayed for a decree from the learned single judge. Stop. Paragraph. The learned single judge passed the following direction. Kore internal page 3 theke bracketed portion. Paragraph. Being aggrieved, the plaintiff is before us by way of this appeal. Paragraph. We have great doubts as to whether this appeal is at all maintainable. Stop. By the order impugned, no right of the plaintiff has been finally decided. Stop. The learned judge has merely asked the plaintiff to make certain queries and place the result before the learned judge. Stop. We also do not see what prejudice the plaintiff has suffered. Stop. Paragraph. Primarily on the ground of maintainability, we are not inclined to entertain this appeal. Stop. The appeal and the connected application stand dismissed. Paragraph. The learned judge, learned single judge, is requested to decide the suit in accordance with law as soon as the business of the court may permit. Huh?
I'm grateful to you.
Grateful. Look, this is my appeal.
Who applied for probate?
My land friend.
You applied. Probate was not granted. And what is your cross objection?
My lord, in the year 2017 of March 2017, probate application has been initiated. Thereafter, in the year 2017 December, one caveat has been lodged by one of the daughters of the deceased, Bonnie Sengupta, before this honorable court. Thereafter, my lord, after lapse of 7 years, now they have come before this honorable court by way of filing a general application which has been registered as GA5. Now they are saying no, that GA was filed under section 148A of Code of Civil Procedure. But in the record, my lord, they have filed the caveat under this original side rules. That is on record, my lord.
Yep. You are the caveatrix.
My lord, I tell your lordship, 2017 probate petition was filed. No citation was ever.
Probate was filed by whom? Who is the executor or?
Son-in-law of the deceased. There are the 3 legal heirs, 2 daughters, 1 son. The brother-in-law is not the beneficiary, my lord. Their conduct is, my lord. They have filed the
Who's the named executor? Is there a will? Must be a will if you have
registered
applied.
will. There is a registered will.
Doesn't matter, it's irrelevant. Who is the named executor?
Mr. Pujon Sengupta.
Who has applied for probate?
Yes, ma'am.
Very well. Sole executor.
Sole executor.
Very well. He applied in 2017.
Yes, my lord, March 2017. Caveat has been filed December 2017 by one of the daughters, Bonnie Sengupta.
Bonnie.
Yes, ma'am.
Yes.
Before this,
Are you Bonnie? Yes.
before this honorable court.
Yes.
After lapse of 7 years, they have filed one general application which
Yes.
has been registered GA5.
Yes.
Wherein they are saying, no, there is no ad valorem duty. They have not corrected the copy of the probate. So in respect of
Copy
that
of probate.
application of probate before the scrutiny department, so and affidavit of assets, now probate has to be dismissed, and their conduct is the caveat which has been filed in the year 2017, that is under 148A of Code of Civil Procedure. But the actual fact is, my lord, they have filed the caveat under the original side rules which has been on record. But they have annexed page number 56, annexure G, my lord, the caveat which is showing, my lord, in the Code of Learned District Delegate at Alipur, but which is incorrect.
My lord, may I reply?
কি ডিসাইড করেছে? কিছুই তো ডিসাইড করেনি।
But my lord, in the order, my lord,
What does the order decide?
my lord, they have not explained as to why they have come after lapse of 7 years. There is no explanation. But now, my lord, single judge, my lord,
Oppose their application. Their application is still pending.
yes, my lord, we have filed our opposition, and wherein we have stated that what they have filed in the year 2017.
Let the learned judge decide that application.
There is an order, my lord. We appreciate, my lord. Page now in our appeal, my lord, memo of appeal, my lord. In course of hearing the application, it came to notice that the affidavit of asset is yet to be corrected and be provided with the particulars as noted therein. Learned counsel for the executor shall furnish the particular as required and make necessary amendments in the affidavit of asset. There is no dispute the fact that the caveat has been filed in the year 2017 by the caveatrix. Now the affidavit in support of caveat has not been filed, and the direction was made to coordinate bench to serve copy of the application of probate to the caveatrix. Now it appears that the asset is to be corrected. Learned counsel for the petitioner
shall cause correction and or amendment of affidavit of asset within fortnight from the date and shall serve the copy of the probate application as well as the affidavit of assets to be proposed caveatic since the caveat is there on receipt of the required application along with amendment affidavit of asset within 8 days the affidavit support of caveat shall be filed. My lord, that is not correct because my lord, they have not explained in their general application. They have lapsed 7 years. There is a specific provision, my lord. Within 8 days, they have to file their affidavit in support of caveat.
Anything else?
No, my lord.
Issue.
That's-
এখানেও this appeal is directed against an order dated July 15, 2025, passed by a learned judge of this court in GA 5/2025, filed in connection with PLA 96/2017, by the your name is Bonnie.
My lord, Bonnie Sengupta, alias Bonnie Sumanto Dasgupta. My lord, Bonnie Dasgupta, alias Bonnie Sumanto.
You are the respondent in this.
My lord,
Hey, state petitioner.
I have been described as daughter of the testatrix.
In the cause title?
Daughter of the testatrix and respondent.
Respondent, yes. By the respondent. Yeah, by the respondent. Paragraph. The short facts of the case are that one Onima Sengupta died in the year 2017.
2015, my lord.
2015, leaving behind a will and testament dated?
My lord, will and testament dated 28 January 2010.
January 28, 2010. It appears that the present appellant was named as the executor in the said will. Stop.
My lord, there were two, what my learned friend has submitted, my lord. There were two executors. Kindly come to page 33. My lord, towards the bottom, Otro Wheeler has my lord been pleased to find. Otro Wheeler executrix নিযুক্ত হইবে তাপসী দাশগুপ্তা উক্ত এক্সিকিউটিভস বিনা জামিনে উপযুক্ত আদালত
33
30 কোনটা কোনটা দেখাচ্ছিস
Have you annexed the will?
My lord, I have a copy. If you'll
Give it.
It's slightly marked.
Facts so জানেন না। Executrix তাপসী দাশগুপ্ত।
না আমার না এটা নয়
Exactly. You are Taposhi.
I'm Pujon Sengupta.
Taposhi has passed away.
It's number 43.
When did Taposhi pass away?
No, my lord. There was a two executor, one executor and executrix. Alternative.
Have you read the will?
Yes, my lord. Taposi was denied.
Even by alternative.
My lord, there was
Taposhi was appointed as the executrix.
but she denied to file this application of probate.
You should tell us that.
Yes, my lord. I'm sorry, ma'am. Out of which, my lord, this application has been filed by the Sengupta.
It appears that the present appellant's wife, Srimati Taposhi Dasgupta, was named as the sole executrix in the will. Of the will further provided Yes. Why are you?
Taposhi Dasgupta's husband is Ramendranath Dasgupta.
Oh, I see. Achha, right. Sorry. It appears that one Srimati Taposhi Dasgupta was appointed as the sole executrix of the said will. So the will further provided that in the absence of Taposhi Dasgupta, comma, the Pujon Sengupta being the present appellant, Pujon, Pujan, appellant ekhane je, Sengupta, comma, the present appellant would act as the executor of the will. Stop. Paragraph. Pujon applied for probate of Onima's will by filing PLA 96 of 2017. Sometime in March 2017. Stop. The present respondent, being Bonnie, filed a caveat in December 2017.
No citation has yet been issued. That's the only case.
Stop. Paragraph. What you filed GA5? Why? What was the prayer?
My lord, I tell your lordship.
Just tell us what were the prayers in GA5?
Of the probate petition, and in the alternative, leave be granted to me to file a caveat
Affidavit in support of caveat.
Caveat and affidavit in support of caveat. Because that caveat that I filed, well, that cannot be treated as a caveat under this under chapter 35.
So you had filed the caveat under 148A. Oh.
Because no my lord understands that.
Highly appreciate, my lord. In the report, my lord, they have filed the caveat under the provisions of original side rules. That is on record.
Under section 148 capital A of the Code of Civil Procedure. Stop. No affidavit in support of such caveat has been filed till date. Madam, have you annexed their application GA5?
Yes, my lord.
Where?
My lord, master summons is there at page 21.
Page number 21 onwards, my lord. Annexure A.
Achha. Paragraph. Sometime in March, 2025, the respondent herein filed an application in the probate proceedings being GA5 of 2025, praying for the following orders. Stay petitioner, page 21, 22 theke. Prayers A theke E. A theke E. Set out, huh? Paragraph. It was on the aforesaid application that the learned single judge passed the order impugned in this appeal. Stop. The order is a short one and reads as follows. Order set out kore debe. Chotto. Memo shonge ache. Impugned order jeta. Paragraph. Being aggrieved, the applicant for probate, being Pujan, has come up by way of this appeal. Paragraph. We have heard learned counsel for the parties. Stop. We do not see how this appeal is maintainable. Stop. This appeal is not maintainable under the provisions of the Code of Civil Procedure, nor is it maintainable under clause 15 of the Letters Patent, 1865, since it hardly qualifies as a judgment. Stop. By the order sought to be, by the order assailed, the learned judge has not decided any rights of the parties finally. Stop. GA5 of 2025 is still pending before the learned single judge. Stop. The appellant says that he has filed his opposition to the said application. Stop. The learned judge will decide such application in accordance with law. Paragraph. we do not find any reason to interfere with the order under appeal. Stop. The appeal and the connected application stand dismissed. Stop. There will be no order as to costs. Yes, what is your OCOT? In view of this, does it survive?
My lord, matter was not being pressed before your lordship. That is the only purpose. So that they come and argue the matter.
OCOT bolo, in view of the order passed in appeal number to the other. Comma, learned advocate for the
I may withdraw.
cross objector says that you will withdraw, that he is instructed to withdraw the cross objection. Stop. OCOT such and such is accordingly dismissed as withdrawn.
Grateful, my lord.
You're not at the My lord, appeal arising out of a proceeding for revocation of a grant. Interim order passed by which, my lord, the...
To refresh my memory, 263, is it?
Yes, 263. My lord, if your lordship kindly sees the impugned order, I don't think I need to say anything much. My lord, a registered will, which was probated 26 years back, my lord, by the impugned order, without any reasons, my lord, the operation of the grant has been stayed. And by whom? The application for revocation is by, my lord, the deceased had 3 sons and 4 daughters. The applicant who sought for revocation is the son of one of the daughters. None of the allegation is that all the 5 daughters were disinherited. And the allegation is also it's a forged will. Though it is a registered will, it is a forged will. My lord, at the ad interim stage, my lord, kindly have a look at the impugned order.
The probate was in your favor.
Yes, my lord. All the 3 sons.
Probate was in favor of the 3 sons.
3 sons.
You appear for, they are all appellants here?
Yes, the all appellants. All appellants.
Let us see the order.
Some remote reason, some prima facie finding of the judge.
Probate dated 21st December.
দেখেছি page 42.
Yes.
And well, one interesting thing, well, kindly I'll bother. Well, kindly have a look at this. Ad interim, let there be an ad interim order in terms of prayer F.
What is F?
Well, kindly have a look at F. It's at page 42. And that would include prayer A to D. And my lord, this is the case of the applicant. It's a registered will. The will was probated by this honorable court in December 98.
Clarify staying the operation.
Well, do the properties exist? 26 years.
My lord, in this matter, your lordship, the probate that was granted, my lord, was based on my consent. An affidavit of consent was given, your lordship. Now, my lord, I have come to know about this probate many years later because I say that that very consent was obtained fraudulently. It is not my signature. I have also annexed documents which would show the discrepancy in signatures, your lordship. I had placed that. Thereafter, my lord, not knowing that there was a probate, I had asked for partition to my learned friend, all the respondents, your lordship. Now, subsequent to that, I get no response. I search, and in the KMC assessment, my lord, I find that the properties are in name of Satish Chandra Tarafdar. Thereafter, your lordship, we come to know that we also, upon search, find two deeds of conveyances, my lord, where we see deed of gifts, your lordship.
Yes.
Where we see that the property has been there for the first time. We come to know about the probate, your lordship. Thereafter, my lord, we had filed for the revocation. And if your lordship looks at the certified copies, my lord, the certified copies had been obtained on 28th January 2025. I had no knowledge.
Lala, let your application be decided by the judge. We are not saying anything, but this interim order shouldn't have been passed.
My lord, limited protection be given.
After 27 years, no.
27 years.
Nothing. Whatever your instructing advocate may say, no reason, nothing. Prove your case, have the probate revoked, consequences will follow. But this interim order, no, not at this.
Your lordship may kindly see that the properties are still in the name of Satish Chandra Tarafdar, my lord.
Now,
And I need some protection with regards to the properties, your
nothing.
lordship.
After 27 years, nothing.
My lord, they had also filed a probate of your lordship.
If you say you have come to know about this, that, and the other thing only recently and therefore approach the court, that would also show how much your client was interested in the matter.
Your
27 years is too long a period of time, Miss Lala.
There are suspicious circumstances.
Very
You know, they had applied for probate
Go back.
after 18
Had
years.
the probate revoked. Had the probate revoked.
They had also sought.
Who is this GA2? What is GA2? Two GAs were taken up.
Your lordship,
Well, they have filed an application for perjury.
For perjury also.
One is revocation of grant
one
263
is
and the other
perjury.
is application for perjury.
Correct.
Perjury application has not been taken up.
And ex parte order. Right?
Yeah, absolutely.
Ex parte order without any reason.
My lord, these
And the consent affidavit is before the magistrate.
Your lordship,
What he's saying is not my signature, it is before the judicial magistrate.
Your lordship,
We will not award cost if you stop arguing now. Otherwise, we might.
your lordships.
Absolutely not sustainable, sir, Ms. Lala. This appeal is directed against an order dated June 17, 2025, whereby a learned judge of this court stayed the operation of stayed the operation of grant of probate of the alleged will, capital W, dated 20th March 1978 or 19th September 1978 or 4th January 1979 for a period of 5 weeks from date. Stop, unquote. Paragraph. It appears that the present appellants, being the three sons of the testator, were named as the executors, joint executors.
First appellant is the executor, appellant number 1.
You will know it appears that the present appellants are the three sons of the testator. Stop. The appellant number 1 was named as the executor in the will of the testator. Stop. It appears that probate was granted in respect of the will by this court.
Yes, ma'am, by this court.
By this court, by an order dated December 21, 1998, in PLA 242/1997. Stop. Paragraph. In the aforesaid factual scenario, You are one appellant only.
Yes, your lordship.
He
And
was
the
the
grand
applicant. He
scheme
was the sole applicant.
The present appellant,
The
sorry,
respondent.
the
was respondent.
present respondent,
Yes.
present respondent,
Shurojit Das, my lord.
comma, Shurujit Das, who appears to be a grandson
Yes, your lordship.
of the testator through one of his daughters, comma, filed 2 applications before the learned single judge, being GA1 of 2025 and GA2 of 2025, comma, sometime in May, comma, 2025. Stop. GA1 is perjury.
GA1 is the
Revocation.
my lord. GA2 is the
GA2 is
perjury.
perjury.
GA1 of 2025 is an application for revocation of the grant of probate. Stop. GA2 of 2025 is an application under section 340
Yes, your lordship.
of the Code of Criminal Procedure. Stop. Paragraph. Huh? Oh, এখন তো BNSS.
Changed, your lordship.
Oh, what is it? Just tell us, ওটা CRPC হবে না। 340 তো হবে না, অন্য কিছু একটা হবে। Corresponding যেটা দেখে বলছে।
379 of Bharatiya Nagrik Suraksha Sanhita 2023.
ভারতীয় নাগরিক সুরক্ষা সংহিতা। দেখে নিও বাবা বানান টানানগুলো। 379.
Let me have your lordship's kind leave, my lord.
Yes. না corresponding হলে দরকার নেই। আচ্ছা ব্র্যাকেটে দিয়ে দিও corresponding to, কারণ ওটা অনেকেই বুঝবে না। ব্র্যাকেটে corresponding to section 340 of the Code of Criminal Procedure. Stop. The matters were taken up for hearing on June 17, 2025, by the order of 25, when the impugned order was passed ex parte. Stop. Paragraph. Being aggrieved, the 3 sons of the testator have come up by way of this appeal. Paragraph. We have heard learned counsel for the parties. Stop. We are unable to sustain the order under appeal. Stop. The applicant before the learned single judge approached the court almost 27 years after probate was granted by this court in respect of the testator's will. Stop. No reason has been recorded in the order impugned as to why an urgent ex parte order should have been passed. Stop. In fact, there is no reason at all in the order as to why an ad interim order is warranted. Stop. Warranted after 27 years of the probate having been admitted to, the will having been admitted to probate. Stop. There are decisions of the Honorable Supreme Court, decisions galore of the Honorable Supreme Court, which have repeatedly said that particularly when an ex parte order is sought to be passed, reasons should be recorded in support thereof. Stop. If one needs to refer to such a decision, one may look up the decision in Shiv Kumar Chadda. Shiv Kumar Chadda, তবে পুরোটা বলতে পারবো না, দিয়ে দেবো তোমাকে, হ্যাঁ, versus Morgan Stanley. Citation বলে দিয়েছি, তুমি মারলে পেয়ে যাবে, 90s এ। Shiv Kumar Chadda, 1993. কার্তিক দাস না, তাহলে শিব কুমার চাড্ডাটা দেখে নিও 93 থেকে, আর কার্তিক দাস ভার্সেস মর্গান স্ট্যানলি ওটাও দেখে নিও। মর্গান স্ট্যানলি, MORGAN, মর্গান, STANLEY, স্ট্যানলি, 94. Top paragraph. In view of the aforesaid, the order under appeal is set aside. Stop. Is set aside. Stop. The learned single judge is requested to decide the two applications filed by the present respondent, in accordance with law, uninfluenced by any observation made in this order.
Your Lordship, they had already sought directions for filing affidavits in the matter. And they have not yet filed. my
Not
lord.
yet filed?
Not yet filed.
When will you file? The time has expired.
Today the matter was fixed, my lord.
Time has expired, my lord. The interim order had been extended up till today.
Order has gone now. Should we extend the time for affidavit?
Kindly extend, my lord, we will file it.
Paragraph, the respondents in the applications before the learned single judge will be at liberty to file their affidavit in opposition. Affidavits in opposition. How long was given initially?
28th July.
I just checked.
No, nahi hai, na?
Your Lordship, on 28th July, time was given till 25th August.
Long time. You have not filed. File it within 1 week.
My lord, we'll do it.
Within a week from date. Stop. Reply thereto, if any be filed within a week thereafter. The matter will be listed before the learned single judge after exchange of affidavits, as aforesaid.
My lord, matter is already listed today. It's running in the list today.
Yes, but then it can't be heard.
Yes. Grateful, Your Lordships.
To appeal and connected application. Disposed of. Disposed of. Not dismissed. Oh, Gure.
I think it's
I am for the response.
Lordship. दे दो, ठीक है? Lordship, three wills, and it was proceeding. Issues were going to be framed. All of a sudden, they come up with a application for leave to file caveat, unheard of at that stage. They have been watching, participating, and that was unfortunately by a order where your lordship, no reasons are there, was allowed. Just after that memo of appeal, the impugned order is there, your lordship. Now, 66 to the KD. Let us go through the order once, Mr. Good.
Lordship.
It's 66 to the order type. Impugned order type. Impugned order last. देखे ना टाइम फालतू टाइम जाচ্ছে মেমোতেই তো বার করো আমি এটা কতখানি করো ওর বিফতে ওখানে গুলিয়ে যাবে पता मेरा पता नहीं শিলাদিত্য চ্যাটার্জি TS number 25 of 2023 is at whose instance? That's mine. Your? Yes. That was initially PLA number?
356 of 2022.
356.
Your lordship, at page 89, there is a chart which might assist your lordship of this stay petition. The three
and PLA 404?
PLA 404 is another probate proceeding at the behest of some other person.
That couldn't have been numbered as TS number 25 also.
That's it. So that is being
as recorded in the order.
Yes, that's a mistake. Yes.
At a mistake that they carried in their cost title.
Your lordship, the chart I was
হ্যাঁ, যে নোটিশে এখানে কোনো দেখাচ্ছে যে কন্টেনশিয়াস ক্লজ হয়ে গেল, তোমার ইস্যুস ফেললে ওরাই লিখলো, তখন বলছে এটা তো মুখ্য। এটা ভালো কাজ না, আগে আগে তো এটা বলা হয়। You are busy, yeah.
Yes.
Lordship, the chart I was referring to,
এই চার্টটা দাও তো
this
ভাই।
chart
Amulad,
says that page
This
82
second
of the
25
stay
will be
application.
24. Rest is same.
Hmm?
Second 25, TS 25, the second 25 mentioned in the order impugned will be 24 of 2023. In the second, first paragraph of page 2
First paragraph, page 2.
of the order impugned, Lord,
এইটা
this would be 24 of 2023.
PLA 404.
Yes, 24 of 2023.
It says page 82. 82 টা একটু বার করে দিন।
$79. This chart,
Yes, Lordship.
$79.
What imagination is
Oh, in my copy, page 79. In my brother's copy, page 82.
Very unfortunate, Lordship.
No, but yours is also 82.
Luckily 82,
So
yes.
that's the majority. What is your
82. I joined that
82?
club.
Only I am 79.
This is totally unfair, Your Lordship.
Yes. আচ্ছা, এটা হচ্ছে নিরোৎপল TS 25, শিলাদিত্য হচ্ছে 24, বিজয় ঝা। How are you related to the testator? Are you?
Yes, কি রিলেশনটা কি বলা করবে তো?
শিলাদিত্য.
Yes.
You are শিলাদিত্য. How are you related to the testator?
দেখো, I'll just refer to Lordship.
Under the will which you are propounding, Bijoy Jha, you are not a beneficiary.
I am a beneficiary. All three of the none. There is no first class share of the deceased.
Mr. Guptu, then prima facie, he will have a caveatable interest. Whether he will succeed or not is an entirely different thing.
Lordship, I'll just interrupt. The point that I am urging more strongly, vociferously, is that they participated, they participated in the proceeding, full notice. It went on till the stage of issues framing, and there they suddenly come up with an application which is totally giving a burial to the original side rules.
Bijoy
and it's not
participated.
allowed.
Bijoy
Yes.
in
yes.
what capacity?
Lordship, page 66. Page 66.
Bijoy was filed a caveat.
No.
No, Bijoy didn't. That is why the application which has been allowed is for leave to file caveat.
So
Now they come.
Bijoy will come up and say, I didn't know about these proceedings. I have a will of the deceased.
Oh, no. That's what I'm saying, Your Lordship. It was all these matters were heard analogously. Yes. And your Lordship will kindly come to page 66. At page 66, they themselves, it was a discovery stage. Contentious cause. Page 66, then that would be 63 in your Lordship's copy, perhaps.
Dated?
This is 28 January. There's a letter.
Later.
63.
28 January.
28 January. Your Lordship, they are writing, and the order is just after this. And all the cases are tabulated above that. That please allow me to inspect the record for discovery and inspection of documents of the aforesaid suits in terms of the order dated such and such by Honorable Justice Krishna Rao on 31st January at 3 p.m. in the above goods. And the order is just after that, Your Lordship. TS4. It's not even PLA, it's TS4, page 68. That would be page 65, page 65. And the next page, Your Lordship, Mr. Lutful Haq, Learned Counsel, is appearing for the plaintiff in TS4, submits that no discovery and inspection of the documents have been completed, and accordingly, parties are directed to complete their discovery and inspection of the documents in connection with TS4 within 2 weeks. Affidavit of documents be filed within a week thereafter. In the meantime, parties are also directed to exchange their suggested issues. So all this is going on, Your Lordship, analogously. All the matters were heard. TS25 was with it. And the intention, for, if I may mention, Your Lordship, is to delay the proceedings. And it is a complete dangerous precedent, abuse of the process at this stage, Your Lordship, to come up with this application. Original side rules is given a complete burial, unheard of at this stage. And then this is being done, Your Lordship, just a walk-in caveat anytime after participating for so long.
Since 22.
Yes, and this is going on since 2023. 22 was that last order. এটা ওদেরই তো 401 এটা আমরা করেছিলাম অ্যাপ্লিকেশনটা আমাদেরটা তো অর্ডারটা রয়েছে সেগুলো তো পরে মেরিটে আর এটা আমি দেখি যদি ফেব্রুয়ারি এখনো আছে ঠিক আছে আমি তো এটা দেখাবো ঠিক আছে তো এটা ওদের অ্যাপ্লিকেশনে আমরা করলাম তাই তো তাতে অর্ডার যে এনি আদার যদি থাকে বলে দিবে সবাই তো ওটা কি অ্যানালগাস
That order is of February 24, defined exactly
Yes, and another order is also there, Your Lordship, at last page 101. That would be 98 in Your Lordship's.
Yes.
Here it was there in their application 401, Your Lordship. Then next page, second paragraph, the last second paragraph, the last line. It was also directed any other caveator, if wishes to file the affidavit in support of carrier, should do so by 19th February 2024. This was also directed. I mean, it's. They filed. Original set rules 35 barber. But it is.
What prejudice will you suffer, Mr. Gupta? If he is allowed to contest your suit, all are being heard analogously. All the three suits. Any one will be probated. More than one will can't be probated.
Hopefully, yes.
What prejudice will you suffer? Because rightly or wrongly, he may be propounding a forged will. We don't know, nor are we concerned.
First of all, Your Lordship, I'll come to the prejudice. The order is absolutely an illegal order. First of all, as I've been pointing out. Number two, prejudice-wise, Your Lordship, it's
Inherent power. Such orders for the ends of justice. Chapter 30. Correct কি দেখলাম একটু আগে 35. These rules মানে নিশ্চয়ই original side. Yes.
Your Lordship, if I may say, prejudice, not just me, everybody will face a prejudice from henceforth based on this dangerous precedent. Anybody would then walk in to any proceeding and want to file a caveat, giving a total go-by to the illegalities. And this is, so not only, I mean, this would be a absolute affront to common sense to accept this sort of illegality, which would prejudice everybody for all times to come now. Unheard of. Gross delay, yes. And of course, that is the main issue, Your Lordship. And then their right to contest also goes as a result of this. The consequence has been outlined in 27.
There are at least three provisions in the original side rules in
Yes.
chapter 38 and 35.
Yes.
Under which the court has the power, even something akin to inherent power also, apart from specific power, to extend or abridge any time fixed for performing any act by any litigant. That's chapter 35, rule 46, and chapter 38, rules 20 and 21.
Absolutely. I'm completely in agreement with Your Lordship. The only thing is that would only be granted to persons who are coming with some semblance of propriety, and not in this sort of scenario where, Your Lordship, they have completely abused the process. They have watched the proceedings. It's at the discovery stage. If this reward is granted to them, Your Lordship, then my respectful submission would be, if I may say so, and this point has not been dealt with also by the court below.
That is all.
No, I will trouble Your Lordship only if there are some judgments also, if required. Otherwise,
No, we are against you at this point of time. So
Lordship.
we are inclined to allow him to participate in your suit. So,
Lordship, then Your Lordship, there is one judgment, somewhat, I mean, although not so many wills, but similar.
in your experience, in testamentary jurisdiction, maximum of how many wills you have found a testator has left behind? I found in a case 7 propounders.
Yes, I remember, Your Lordship, last time it was 2 or 3 we were dealing with. This is 3 as well.
Yes.
These days keeps on increasing. This is 2010 3 CHN 686.
Better copy of it.
দেখছি Your Lordship, this if I may read, or I may.
Para 8.
Yes, first paragraph is the factual situation, Your Lordship. Para 2 also. And then, yes, para 8. I find, if I may read that, paragraph 8 perhaps. I find substance in the submission of Mr. Mitro that any person cannot come in any time, at any time, even if having caveatable interest, as Chapter 35 of the original side rules of this court has provided the method of hearing of an application for grant of probate. Rule 24 of Chapter 35 provides for lodging of caveat in anticipation of any person interested in the event any application for grant of probate or letters of administration. The person who has lodged caveat is entitled to file affidavit in support of caveat within 8 days as mentioned in Rules 25 and 26. Under Rule 20, once it is found that affidavit in support of caveat is filed, the same is treated as contentious cause and treated as a suit. Rule 27 provides for consequence of not filing affidavit. The plaintiff has lost his chance to establish his right to contest the grant as he neither lodged caveat nor filed affidavit in support of the caveat. Your Lordship, then paragraph 9, after this, third line from the top, paragraph 9. I am not impressed with the contention that just because the applicant is a co-executor along with Ganga Prasad Birla, he can join at any time, whenever he thinks. It appears to me that gentleman was sitting at the fence, watching the fate of the caveat lodged by Ganga Prasad Birla, and having found Ganga Prasad Birla being successful, he now wants to take the benefit of the said judgment. Such fortuitous circumstance cannot be a foundation to claim right to contest the grant of his own. Your Lordship, here, he sits on the fence, he lets the proceedings go contentious and till the discovery, till it was framing of issue stage. Then he wants to delay the probate of mine. That is why he comes up with this frivolous application. And there was also there were orders where it was time was granted, stimulated. I've shown Your Lordship. So in this backdrop,
whose application is the first in point of time?
Mine.
Application
I'm
for
the
probate.
oldest applicant and the first last will.
All
Both is
the
in my
more
favor.
reason that he should be allowed to.
Why did you apply so late?
But only I have explained that I have played for condonation of delay. I applied. I given the explanation why I was late. My client is not from Kolkata. He's not stationed in Kolkata. He had engaged an advocate. Advocate was contesting their suits. All these three suits were together analogously heard. The other two applicants of probate, they have exchanged documents amongst each other and made those suits contested. And they also lost caveat in my suit. It is at that juncture when ultimately when they came to me, I advised them, unless you file a caveat in those proceedings, you will not have a chance to contest them. They were contesting mine, but there was no advice to file a caveat. I have given that entire pleading there. The entire explanation is there. And this point which is being argued now was not even argued in the court below. I was
no,
there.
it is not dealt with. It is not dealt
Not even
with.
argued. Not even argued. I was there. I had moved the application. Not even argued these points.
Your Lordship, page 96 also, there stand. It was said that condonation was paid for. Absolutely no condonation was paid for. It's there on record, their affidavit. It's at page 93, it would 93, it would be in Lordship's. Let us see their stand. They did not come for any condonation. If I may read that paragraph. G at page 5. Internal page 5. Third line from the top, the applicant is seeking opportunity to lodge his caveat, an affidavit in support of caveat in the instant proceeding. Since no citation was issued upon the applicant, the time to lodge caveat is yet to start, and therefore the question of delay or laches does not arise and cannot arise. I tender my unconditional apology for not being able to file the instant application.
My laboratory probably is reading my reply. Kindly read my application at page. The application, I will have obviously pleadings of condonation in my application, not in the reply. In the reply, they are saying I am late. I say there is a starting point. I can't be late. Paragraph number 9, 10, 11, and 12. I have given categorical pleadings in respect of why I got late. And I also took a point that the document they showed that I sought for inspection in January. I took inspection. I found them these to be the forged wills, and I filed application in February.
You know, hey.
Order dated August 4th, 2025. Also by single judgment, single judgment scope. Thereby allowing the said application and permitting applicant i.e. the respondent before us file a caveat in respect of grant of probate of a will dated April 17, 2018. Good stop. From the material before us, it appears that the testator namely Dr. Basudev Banerjee had left behind paragraph dated paragraph it's dated April 2018.
No, I think it's yours. This is mine.
September 11, 2018 का पूरा with the data sequence.
Probate ছিল না 3টে in all. 3টে proceeding গুলো দেখতে। 3টে proceeding আছে। না রে, 3টে proceeding আছে। একটা নীলাদ্রি কি
3 weeks. 3 weeks. তারপরে March and the bill is March 10, 2021.
But my application is annexed at page 40 of the stay application. Page 40 is the master summons. The application body starts from the page 45. Affidavit starts from page 45.
Pages are 40, 42, 41. Page 40, 41. Set out for us. That application content. The applicant has stated that where is your application? Where is your explanation? Which
That paragraph 9 and paragraph 10. Paragraph 9 is the inspection. I took inspection, found this will to be a forced will, and I filed the application in the month of February, next month.
Explain the delay occasioned by the applicant which on the scope filing the forced application following it up. Application. This said application has been allowed by the order. Hence the present appeal. The group 2 and the advocate appearing for the appellant has criticized the order by asserting that the order is setting a bad precedent. Order would be setting a bad precedent in as much as the same gives an impression that any person alike to the applicant can walk in at his leisure and seek participate in a proceeding, throwing all rules on the original side to the winds. Full stop. Paragraph. To the wind. Paragraph. He relies on a single bench judgment of this court in the case of a the case of in the goods of such and such person such as reported at full stop. It is submitted that this court had similar situation refused to allow a party to join the proceedings and contest the same. Full stop. Paragraph. The advocate appearing for the respondent points out that the applicant stroke respondent was prevented by sufficient cause from approaching the court within the time stipulated in the rules. Full stop. It is submitted that in any case, the will whereof probate has been sought. Now, the application for probate of the will alleged to have been executed on April 17, 2018 has been filed subsequent to. Your application is prior application or their?
Mine is the first application for grant of probate.
Subsequent
I filed in 2021.
application for probate filed by the applicant. Full stop. Paragraph. We have heard the learned counsel appearing for the respective parties. And
Filed by the applicant and appellant. Last letter.
applicant, we filed by the respondent.
And one more fact, my will is, and the will that I'm carrying is the last will.
Again, the respective parties and considered the material. Full stop. Paragraph. It is not in dispute that the application filed by the respondent seeking probate of the will said to have been executed on September 11, 2016 is prior in point of time. His application is prior to yours. It's prior in point of time. Show that.
From the chart, it would appear.
Prior in point of time. Then that of the appellant before us.
Lordship, sorry, interrupt. His will is actually, will date is 10th March 2021.
Will is later.
PLA is first.
I have the last will and the first PLA.
Right, right. Made in the application seeking leave to join the probate proceeding and issuance of citations upon the respondent. Paragraphs 8 and paragraphs 9 and 10 of the said application which have been extracted here in above. Sufficiently explained why respondent could not approach this court earlier and intervene in the proceedings. We stop. Paragraph. Since he is also a beneficiary in course of arguments upon a query of court, it was submitted on behalf of the respondent. You said that you are also a beneficiary in the will.
I am a beneficiary under the will that I am propounding.
It has been submitted on behalf of the respondent that the respondent is also a beneficiary in the will dated March 10, 2021. Probate whereof has been sought by him. Therefore, it cannot be denied. Respondent has a creditable interest in the will. Paragraph. This is in addition. This is in addition to the fact that he himself has sought probate of a will executed by the same person of whose two other wills are lying for the purpose of grant of probate. Paragraph.
দুটো সুপ্রিম কোর্ট যে রেফার করেছে সিঙ্গেল জাজ, সুপ্রিম কোর্ট দুটো রেফার করেছে।
We have noted that single judge has referred to two judgments of the Honorable Supreme Court rendered in the cases of a page memo, page 2 of the interim page 2 of the order. The judgment can refer page 2. Memo. Judgments rendered by the Honorable Supreme Court in the cases of such and such versus such and such, wherefrom it is evident that in case a claim as to grant of probate is found to be prejudicial to any person who claims benefit under a will, such person is said to have favorable interest in respect of the probate proceeding. Full stop. We therefore do not find any reason to deviate from the decision ultimately taken by the Honorable Single Judge. Full stop. Paragraph. As regards the judgment in the case of Priyambada Devi Birla, Supra, cited by the appellate, appears that said case, the person who sought to be added to the proceedings was indeed a fence sitter. There was fence sitter, full stop. There was no attempt to justify the delayed approach to court. Full stop. In the case at hand, comma, as we have already discussed here in above, comma, we are satisfied that the explanation put forth by the respondent is sufficient.
Is a plausible one.
Is a plausible one. Full stop. Paragraph. No, is a plausible one. Sufficient one. Is a plausible one. Full stop. In this connection, we may also refer to
for that. Order 35 rule by Honorable Chief Judge. The 45. So chapter 35A, right?
chapter 35A of the original side books, which reads
It's chapter 38 of the other.
as well as 46, 46 of chapter 58 of the schedule. Every principle. It does not appear that by allowing respondent to participate in the probate proceedings and to file caveat in respect of the grant of probate, the Honorable Single Judge has heard so as to warrant interference by the appellate court. Full stop. Paragraph. For all the reasons aforesaid, we dismiss the appeal, the APUT now. No cost.
Only one thing may be recorded. I have already lodged my caveat in the department in terms of the order. I have already lodged my caveat in the department in terms of the order impugned.
Oh, you have already lodged.
So order has been completed. That may be recorded.
The appeal was infructuous, Your Lordship. They've already done.
I did not want to.
Granted, the court taken for granted.
Appeal was filed later after I lodged the caveat.
That the respondent has already lost
Before this appeal was filed.
before the appeal was filed, before the disposal while the appeal was pending or before the filing of the appeal?
No, before the filing of the appeal. After that, they filed the appeal. I did not want to take that technical point. That's why I did not.
You should have told us that.
I know, but I did not want to take the technical point.
Thank you. No, ঠিক আছে, ঠিক আছে.
রিলিজ হবে Milad 12 Milad Milad had already released the earlier appeal. The AI Chabdani Milad family Milad the Wadwas. This was the last order.
No, they should. The Wadwas.
Yes.
We are not inclined to take up this matter on the personal ground of one of us, Aman Namdeve. Paragraph. This matter stands released from our list. Let this matter stand released. Let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction.
Lovely.
Item number 6. My appeal with regard to the registration of the deed of conveyance after a partition decree.
Yes. What do you have to say, Mr. Kaur? Are you opposing the prayer?
Lordship, not really, but there's a problem with the decree which has been passed. Lordship, what has happened is the decree asks for execution of a deed of partition. It doesn't declare the partition itself. The Lordship will kindly take the decree once.
Well, then, to mushkil. The decree has to be followed. And if the decree requires execution of a partition deed.
Not a partition deed. The decree says, Learned Commissioner for Partition shall execute and register necessary registered deeds. This is a partition decree. And we are challenging the decree only on this ground. That there is already a partition. Parties are in possession. And so there is no requirement of further registering separate deeds of conveyances in respect of each of the shareholders. Partition decree will itself.
Registration is not necessary also.
For a partition deed, it is.
Interest will pass.
No, my lord.
But they already had interest in the property.
No, it's joint.
It's joint property.
Then.
But the registration act says.
You're partitioning it. You're dividing it.
Yes.
How will that be affected in law without registration?
But that is provided in the Registration Act, section 17(2)(c). It's provided, it's not required. Only those deeds which are specified there are required to be registered. Only those decrees which are specified there are required to be registered.
Is registration and payment of stamp duty the same thing?
No, payment of stamp duty is different. The decree will not require registration.
But insofar as the stamp duties are concerned,
You are really concerned with the stamp.
well, that is also, yes, well, that is also one of our grounds, that stamp fund which is payable by each of the persons parties to the suit will be as per their separated share in the property.
সেটা তো I can understand.
That is right. That is right. But দেখতে হবে, because if the decree is read as a document creating title, this will require registration. If it only lists the properties, suppose they had already partitioned by meets and
Secretary and
there's
the difficulty to
it will not require registration because it is not creating anything. But if it is creating any right in respect of an oral partition document, but has already been partitioned,
But এই তো সেপারেট শেয়ারটা ইন ল মানে জয়েন্টনেসটা ভেঙে যাবে উইদাউট রেজিস্ট্রেশন।
it won't. Severance or something in that case.
What is happening really? আমরা জয়েন্ট ওনার দুজনে একটা প্রপার্টি, আমার ফুল ওনারশিপ পুরো ফুল ওনারশিপ, এই ফুলের হাফ আমি তো তুই ফুলের হাফ আমাকে দিয়ে দিচ্ছিস। এবারে তিনজন থাকলে ওয়ান থার্ড কোন পার্টিশন করলে কি হচ্ছে, ফুলের আমি দুজনকে দিয়ে দিচ্ছি, ওয়ান থার্ড আমি যাচ্ছি, এটাও তো একটা ট্রান্সফার। I had, I relinquish in.
My shares have been
You have annexed the decree?
Yes, page, it's annexed with the memo. Okay.
उफ, वहाँ मुश्किल है।
Yes, madam.
Prima facie appears B and C of section 17(1), which says any non-testamentary instrument creating right has to be registered. But B and C will not apply to A, B, C, D, E, which includes decree or order of court.
The exemption is in 17(2)(6).
Correct.
So that exemption over here, the difficulty is had the partition taken place by virtue of the decree, it would not, because there is no additional properties. So it would be restricted and there would no registration would be required. But the stamp would be payable under the Stamp Act. But in this case, the moment the court finds that a decree is, the Learned Commissioner Partition shall execute and register necessary registered deeds. The moment the question of deeds come, it has to be registered. Your Lordship, the difficulty perhaps comes from the Stamp Act, because they give a
After 2 or some other day.
2 o'clock, led by Mr. Banerjee. Your Lordship, I may keep it at 2 o'clock. We'll come back at 2.
2 o'clock, there is a fixed matter to be mentioned, which may or may not take long.
But we'll be there.
After that. Mr. Ghosh, we have noticed you are here, but at 2 o'clock, there is a to be mentioned matter fixed. After very well. থাক, এটা রাখো।
The appellant, and it has come up at the instance of the joint special officers, my lord.
Yes, why do you need police help?
But we oppose that, my lord. We are the, I'm appearing for, my lord, the company which has purchased the, my lord.
If they have no, if somebody resists you, put that in your report and submit your report.
But all these allegations we deny, my lord. These allegations have been.
We are not taking note of any allegation.
Lordship,
Fine, no order, out of list.
I'm very deeply obliged. my lord.
Time period. Well, how much time do you require?
Lordship will take the order once, my lord.
Don't oppose this extension of time period.
But there are two things. One is extension of time to complete the inspection.
Yes.
And the second is extension of time to submit the report.
So tell us both.
Well, Lordship will kindly take the, perhaps there is no time required for submission of report.
Or extension of time to carry out further inspection. Records are necessary from the court.
Minister.
The area of land was vast.
Sir, please understand, all we are doing, we are extending the time. Whatever direction there is, there is. We are not adding or subtracting or altering.
Only one perhaps observation would be required, my lord. The special officers asked for certain the documents and particulars from the purchaser.
Which have been given, that's my instruction.
They have not, I do not know, Lordship, if they have given, Lordship, I do not know why this report is not
It's there in the email which we have, my lord.
We have received certain questions were put to the purchasers. We have received the answer on email. We have got it late on the 27th, whereas the inspection was put on the 23rd. That can maybe out of the
perhaps.
The only thing is that the entire inspection was not completed because the land and area was
We are repeatedly asking you how much time you require.
Another 30 days will be required to complete the
And then within what time you will file the report thereafter?
within 10 days thereafter.
Within 10 days thereafter, which is the order which requires you.
Lordship kindly takes the order, Lordship, and Lordship takes page 18 of that order.
Last paragraph.
Page 18 of the
With a period of 30 days.
In page 18, Lordship, we order as follows: the purchaser, Dhruva Woolen Mills Private Limited, shall disclose in all agreements for sale and deed of conveyance or deed of lease or any transfer entered into by them with a third party with respect to the subject land at Thane, the subject matter of dispute in CS 12 of 2009. Lordship, that has to be mentioned by them, and that is why the special officers ask for those documents. But
At the moment those documents, I do not know, perhaps my learned friend is not instructed properly. The moment this was inquired of, my lord, we have given it immediately by an email. I'm carrying a copy
the
of the
information was given, not the documents.
Everything has been given.
Issue.
Lordship, the special officer saying no documents.
Let them say so in the report.
My lord.
Then the court will see.
Lordship.
Time for the special officers, joint special officers, to conduct and complete inspection of the concerned property is extended by a month from date. You said 30 days.
after the reopening of the court.
For entire 1 month, they are not here. Take the microphone. We can't hear you.
My lord, I've been instructed that they're not here. They're going for some medical treatment, so it'll take some time.
No, but you have 3 weeks before that also.
Very well, my lord.
So till 2 weeks after the puja vacation, extended by a month na kore, till 2 weeks after the puja vacation, date ta diye dao. 7th November, November 7. Stop. Within 10 days thereafter, they will file the report that they were directed to file by the order dated
30th July.
September 30, 2024. Stop. That is all.
Lordship, one thing. The plaintiff number 1, He was personally present. The learned advocate of the defendant number 3 was personally present. They were threatened that unless they leave,
Absolutely, my lord.
unless they leave, that is
want to
part
make
that
then
is
put
part
it
of
in
the
an
minutes.
application will indicate. my lord.
We say
Lordship-
nothing, paragraph.
Lordship will kindly
We-
clarify that we are
only
also
clarify
supposed.
that we clarify that all concerned will strictly comply with the order dated September 30,
I'm very deep.
2024.
Very deep.
Lordship will clarify that. Lordship, I can
Only
be
thing, my lord,
present at
I'll
the time of
oppose to
inspection.
that submission because my lord, I'll indicate why.
I don't know if the order permits you.
The order says, my lord,
You are not adding or subtracting from the order.
my lord, the order says that the inspection should be conducted within a period of 30 days from the date of communication of the order upon notice to all parties and their learned advocates. Now, it is the point of the purchasers that the learned advocates are not to be present there when the inspection is being carried out.
You know, the appellant is, my lord, the person who is
We are not
challenging the
going
entire
to.
thing.
We are not going to say anything.
I'm very
today.
deeply obliged. Very deep.
If you think they are illegally preventing you, file an affidavit, file an application, do whatever you can. Just an oral submission, we can't pass an order.
This is part of the minutes, though, but very well, my lord.
And with respect to the inspection, further inspection to be carried out, my lord, if the special
And
advocate
Lordship,
may be granted some additional remuneration with respect to the, because it is a
Remuneration was granted earlier.
6,000 GMs each, my lord.
And Lordship, they were present for 2 days. Second day, because of this chaos, my lord, they could not. Lordship, it should be at the cost
There
of the
was no
purchaser,
chaos,
my lord.
there was no chaos. We had in
It
fact
should be at
requested them to
the purchaser should
come over. They refused to come.
The question of further remuneration of the joint special officers will be taken up on the day the report is filed.
Very deep.
Let the matter be listed under the same heading. 17 November.
May I only, subject to being, my lord, the order, my lord, of 30th September indicates that the report has to be filed before the learned trial court, my lord, because the suits are pending in Thane court.
Oh.
So, my lord, it is not, my lord, returnable.
No. There's no Thane court.
Pending here.
There is a
here
suit
as
here.
well, and my lord, Thane court, but the order records that, my lord, the report of such inspection should be submitted before the trial court within 10 days.
Yes, trial court is Calcutta High Court.
No, but it's on the definitely not the
In the
division
case,
bench.
not the division bench, my lord, that is my submission.
Before the
That's page 18
there is no
of
problem.
the order. In the order, my lord, it's page 18. So, my lord,
Trial
that's why
court
I
is
had
the single judge, learned single judge or what?
The suit is pending before the
honorable
Yes,
single
yes.
judge.
Lordship,
yes.
there's justice.
Let the matter be listed before the learned single judge,
Very deep.
having determination
Justice
to
Pushinjit Vishwas.
take up the matter on September 17 November. Stop. On the learned single judge shall decide how much, decide the issue of further remuneration.
But with respect to the expenses for the inspection to be carried out presently, it will be in terms of the earlier order dated 30.
Yes. Stop. The paragraph. The expenses that are to be incurred for conducting and completing inspection of the property in question shall be borne in terms of the order dated September 30, 2024.
I was praying that it should be, Lordship, at the cost of
Right.
purchase.
Nothing, whatever there is, Mr. Ali.
I'm very deep.
We have not applied our mind. The appeal is disposed of.
Very deeply obliged.
I'm grateful, madam.
Look, this was
Mr. Banerjee, please, we will request you to come back on Friday, day after tomorrow, with some decisions. We are sure 17.
I'll show the judgment when I'm carrying it. While I had the time, I quickly looked up. There's a recent Supreme Court decision which explains what is 71725 and how when it's a decree or a 17. I read it in a hurry. I missed the one. I said 1725. If there is a decree or a compromise in relation to a property which is the subject matter of a suit, then registration is not required. If it's a compromise decree, which anyways is not the case here, therefore I'm not troubling your lordship with that. The test that the Supreme Court has applied, that if it's a division or a decision regarding existing rights, then registration won't be required. If a new right is being created, then a registration would be required. So registration not, I'll cite it, not formally, Your Lordship will not rely on what I'm saying. This is the decision of Mukesh versus State of Madhya Pradesh and another. Your Lordship will kindly have a look at page 9, which is the part of paragraph 7. Judgment. WhatsApp kore dena. Paragraph 7 set out in section 17. Page 9 immediately, if I may. Fourth sentence, Your Lordship will kindly make a note of. The exemption for decree or order of the court under 1726 of the Act 1900 is with a rider. Under the provisions of, under the said provision, but I'm not sure if I'm reading the right portion that Your Lordships are reading. Under the said provision, any decree or order of court, except the decree or order expressed to be made on compromise and comprising immovable property other than the subject matter of the suit, would not require compulsory registration. Then it looks into a distinction which is factually inapplicable here. Then hoopsing and all that is considered, Manoj. Then the entire law on that is traced. That if Your Lordship once has a look at
We will have it on Monday as for orders.
one more aspect, if Your Lordship bears with for 2 more minutes. If Your Lordship looks at 10.1 onwards, I'll not trouble Your Lordship today with the judgment. The other aspect that was really we were troubled with was the direction upon the Partition Commissioner to execute registered deeds of conveyances in respect of each share.
If that is done away with, all problems will be solved.
All problems will be solved. And one clarification.
Why do you need that?
None of us will need that. It's not, it will not any
Tell you when what the difficulty is, the party.
All the parties are before us.
I believe not.
We've served, I'm told unofficially that the others will not come. We've served them once, we've served them again. Because it's really, and the stamp duty. আমাকে তোমার আপনার বইটা দিন না
এটা দাও যেটা স্ট্যাম্প অ্যাক্ট কেন যেটা দূর বাবা প্লিডিংস
One more aspect, if Your Lordships are considering the pleading, your lordship will just make a note of how the preliminary decree and the report of the partition commissioner was accepted and not challenged. So no further grievance in respect of that can be there today. The difficulty is that the offending part of the decree, so to speak, my lord, if I can just show.
Further ordered that the said learned commissioner of partition shall execute and register necessary registered deeds.
This is something I have really never seen. I have, in whatever little practice I've had.
Oh, my brother's papers do not include the last page of the decree.
I'm very sorry, ma'am.
Have it rectified first.
Yes, yes, of
Right.
course. Page 4, my lord.
Memo to.
My lord, Justice Rai doesn't have page 4.
Page 11.
Page 11 of the decree. Dao na ke? Just check.
The drawn up decree. Oh, the drawn up decree. My lord, if your lordship looks at just the decree passed by the
Oh,
court.
I see. সেটা তো মেমোতে পাবো না।
That's the decree drawn up. My lord, the
নাকি এটাই এখানে
memo your lordship will find.
Oh, contains the drawn up decree only.
memo contains the drawn up decree only.
No, my lord, memo
No.
also has the decree of 30th of September 2024.
30th of September 24.
That your lordship will have a look at page 4. My lord, Justice Rai has it, no? The last paragraph. The learned commissioner for partition shall execute and register necessary registered deeds.
Not necessary.
Lordship, it's not true, but then perhaps it has been done in view of the amendment to the Stamp Act. If your lordship say takes Article 45.
I also want to rely on that. That actually exonerates. The stamp now is 1.5 rupees.
No, that is not so. That what my learned friend is saying is the note. Where what happens is when a decree is passed and the decree is adequately stamped, if pursuant thereto another deed is executed, then it comes to 1.0. Kindly take part.
Stamp act এবার দাও।
আচ্ছা একটা দে না তো কপি আছে
আমার কপি আছে
আচ্ছা আচ্ছা
আমার কপি
may I hand over?
Please give.
আরেকটা কপি আছে একটা কপি আছে
এক প্রশ্ন কতবার জিজ্ঞেস করছি
ওইটা পাচ্ছি না তো জজ সাহেব
কপি তুলে দেন may I hand over a stamp act? No?
You have it now.
That I'll place that first your lordships are aware that section 3 of the legislation, the act, has what documents are required to be stamped, because this Supreme Court judgment also considers this issue. I'll show that. I don't know why my learned friend wants to oppose what I'm saying.
Is it your case that it will not require stamping also? Stamping is
At the highest 1.5 rupees. At the highest, I'll show that. Kind level, and I'll show the Supreme Court judgment which considers this. Please have a look at section 3. Section 3. I'll come to the schedule later. Instruments chargeable with duty. Subject to the provisions of this Act and the exemptions contained in Schedule 1, the following instruments shall be chargeable with duty of the amount indicated in that schedule as the proper duty, therefore, respectively, that is to say. Lord, please give this a cursory glance. Your lordship will not find any decree. Now, there's a West Bengal amendment. West Bengal amendment after C, if your lordship sees after clause C, provided that except as otherwise expressly provided in this act and notwithstanding anything contained in clause A, B or C of this
What are you reading?
Lord, section 3, the West Bengal amendment under it. Stamp Act section 3, Milord. All these books have different versions. It's very difficult to. May I hand over one which has it? Oh, এটা তো নেই। amendment in অদ্ভুত বই নিয়ে এসছেন
Section.
এটা কোন সেকশন দেখাচ্ছিস তুই? ও এটা নেই। The 2018 print has the
আমাদের ওটা 2021। আচ্ছা আচ্ছা।
Yeah, primary same. Supreme Court বলেছে না ওটা is a মানে incorrect reading of the section সেটাই সুপ্রিম কোর্ট এখানে ক্লারিফাই করে if stamped in accordance with the person it has to be executed by person ওটা ভুল করছে may I place it your lordships have section 3 my lord with the West Bengal amendment yes now section 3 instruments chargeable with duty subject to the provisions of this act and the exemptions contained in schedule 1 the following instruments shall be chargeable with duty of the amount indicated in that schedule as the proper duty therefore respectively that is to say please give this a glance below instrument schedule not having been previously executed by any person bill of exchange every instrument executed by any person and then there is a West Bengal amendment after clause C please insert sorry provided that except as otherwise expressly provided in this act and notwithstanding anything contained in clause A, B or C of this section or in schedule 1 the amount indicated in schedule 1A to this act shall subject to the exemptions contained in that schedule be the duty chargeable under this act on the following instruments mentioned in clauses AA and BB of this proviso as the proper duty therefore respectively now AA and BB is also every instrument executed by any person in West Bengal. BB is also every instrument executed by any person outside West Bengal. So now, if your lordship now looks at schedule 1A, (45) note 45 not partition if your lordship has it then I will not trouble your lordship with the rest of it my lord the initial bit of it 1/2 of 1% my lord this was my understanding when I advised the appeal if your lordship recalls in the morning also I was saying that I'm entitled to only half share or to my share of because your lordship passed it over I had some time I read it up a little more kindly turns over my lord to 45 how it continues C AB is not applicable to me C where a final order for effecting a partition passed by any revenue authority or any civil court or an award by an arbitrator directing a partition is stamped with the stamp required for an instrument of partition and an instrument of partition in pursuance of such order or award is subsequently executed, the duty on such instrument shall not exceed rupees 1 rupee 50, 1.5 rupees.
It has to be stamped. Yes.
So it has to be stamped but it under schedule 1A and this it doesn't come. Now this identical parameter provision came for consideration this judgment that I just handed over. The amendment of Madhya Pradesh. Your lordship will have a look at paragraph 13.
stamp required for an instrument of partition?
Well, that is not there. So if it is not there, then it will be the at the highest will be 1.5 rupees, which is why I. Well, if I may read C again, where or an award by an arbitrator directing a partition is stamped with the stamp required for an instrument of partition.
If it already contains a stamp, then in that case, if the decree is passed, that has to be read that way.
Well, that is in respect of an award.
No, decree also.
Well, where a decree will not require, probably not. May I just completely borrowed intelligence? Please have a look at the judgment that I've just given.
If you say that this stamping part is to be read along with the award only, then you are missing the comma after a partition.
Yes. Now, if I read it once holistically, where a final order for effecting a partition passed by any revenue authority or in any civil court, or an award by an arbitrator directing a partition is stamped with the stamp required for an instrument of partition. And then, if that is the, that is how I also read it and I wanted, then what will come down to, then you also will look at, comes back to first part of 45. Well, 1/2 of 1% of the market value of the separated share or shares of the property. So I will pay that.
But no stamp is something.
Because this judgment I was reading up for registration. Once your lordship will look at paragraph 13, it holds that it's not required to be stamped because it's a decree. An identical provision. It says that. No, same. Paragraph 13. Paragraph 13, kindly see. In respect of the issue, I did not know this. I was reading it up sitting in court, and then I thought I'll just show this to your lordship for your lordship's kind consideration. In respect of the issue relating to payment of stamp duty for mutation of the subject land, it is the plea of the petitioner of the appellant that consent decrees are not chargeable with stamp duty under the Stamp Act 1899 as applicable to the state of Madhya Pradesh. Section 3 of the Indian Stamp Act so and so provide with chargeable with duty as the same as under. Now, if your lordship turns over, the first proviso is identical to the proviso that has been incorporated by the amendment of State of West Bengal.
No, so in Schedule 1A of maybe the Madhya Pradesh Act, it might have been differently worded.
The court restricts itself just to this from the above because it doesn't come under an instrument.
It says read with 1 or 1A. Read
Correct. That's the.
So it's reading that schedule also. We don't know whether the schedule also underwent amendment in the Madhya Pradesh Act. Must have.
Possible. I did not check up the Schedule 1A.
Schedule 1A of maybe there may be a different amendment there.
Could I just get half a second? Check could I could I just check up the Schedule 1A of Madhya Pradesh Court and come back? Because if it's identical.
Because you see,
I follow.
1A was inserted by the West Bengal amendment.
Correct. And 1A was incorporated by the Madhya Pradesh amendment also.
So maybe their Schedule 1A Schedule 1A doesn't.
Let me just check up 1A.
Check, come back and also consider if your problem will be solved if we remove that one direction for execution of deed.
Then everything is solved.
That's what we are saying. Then why don't we do that and finish it off?
I'll come back on Monday with just 1A comparison, and if I can show 30 seconds that day your lordship will give.
You don't even need that if we remove that sentence.
The stamping requirement will still.
Then come back. Hey, এটা মধ্যে দিয়ে দিয়ে পড়ে আসবো।
Would it be this on Friday?
Day after tomorrow.
Day after tomorrow.
Why Monday you are in difficulty?
No, Monday was not difficult.
Monday is commercial. Friday is also commercial.
Any time, my lord, if you lordship, for like 5 minutes or 10 minutes. I'll just come and show the comparison. If it's there, it's there. Otherwise, it's not there.
কিছুক্ষণ দিন হয় কাম মানডে একটা 15 মিনিটের স্লট দিয়ে দাও না, দেখো গাড়িটা করে। Oh, Monday is a bad day. Then Wednesday. Then Wednesday. Wednesday retaining his position wherever it is. And order karo. We have heard learned counsel for the parties at some length. The paragraph, Mr. Banerjee, learned counsel appearing for the appellant. One appellant.
He is right.
How many appellants?
One.
Seeks a little time to do some research. Paragraph. List this matter once again on Shamri Budbar, comma, retaining its position.
The affidavit of service.
Affidavit of service filed in court today be kept with the records. Everybody has been served, huh?
The advocates who are representing the parties.
All the advocates before the trial court have been.
It will inure to everybody's benefit.
Nobody would want to unnecessarily.
Come back.
Wait.
Mr. Ghosh, this is for the benefit of Mr. Obiji Chatterjee. Roughly how long you will take? Because we will rise at 3:20 as we have a larger bench at 3:30. So if you...
I have assured him that he will not be called as slippery anymore. Because whenever he appeared with me, he used to slip out. I turned around, he was not there.
He said that now it seems you have become more serious.
So can he go?
Mr. Ghosh will take the rest of the day.
If you keep us busy till 3:20, that is for about 50 minutes. Yes? Go.
But only one other prayer is making, since my Leonard Junior is an outstation counsel, can he come again on Wednesday retaining its position?
Yes.
Next Wednesday.
Next Wednesday. Koushik, এটাকে একবারে next Wednesday ওনার ম্যাটার ডেট এটা। আর ওই স্পেশালিস্ট তো দুটোই আছে।
Yes. After Mr. Ghosh.
Yes.
I was placing the trial court judgment. I have placed up to page 18. Quoted. Now finally come to page 20.
Award.
No, trial court judgment. Before they come, well, I place award both. Majority and minority.
না trial court judgment মানে মেমো দাও মেমো।
Judgment কবে দিয়েছি বলো তো?
কোনটা trial court?
10th August, আপনি দেখুন, 10th
Yes.
August 2022. Kindly come to page 20, my lord. I placed right up to the top paragraph. In the present case, the majority arbitrators have taken into account of the major Port Trust Act and TAMP order, which is not available in the contract, and have not considered the chart showing the cargo handling
during the contract period, which was the material document available with page 20. That's good, huh? Available. Consider cargo handling contract, which was material document available with the arbitrators. The minority arbitrator has considered the said document and has also held, in the present case, the parties are to be governed by the private contract and not by the Major Port Trust Act. The learned minority arbitrator also considered the letter issued by the respondent, wherein the respondent insisted the petitioner not to divert the vessel, even on the day the ground stock was 85,009 metric tons. The respondent has protested to the diversion of cargo, not because the petitioner did not fulfill the commitment quantity, but to ensure it does not lose revenue. In the letter dated 20th January 2011, it is also mentioned that diverting of vessels to Gangavaram port would cause huge loss of revenue. In the case reported in AIR 2021, PSA, which was cited by me, it has been held, para 87, the learned judge has quoted, it has been held that the arbitral tribunal is not a court of law. Its orders are not judicial orders. Its functions are not judicial functions. It cannot exercise its powers ex debitio justice. It has been held that the jurisdiction of the arbitrator being confined to the four corners of the agreement, he can only pass such an order which may be the subject matter of reference. In the present case, the majority arbitrators have passed the award by going outside the four corners of the agreement, in spite of the fact that there is no clause in the agreement for levy of demurrage against the petitioner, and have considered the Major Port Trust Act, which was not the subject matter before the learned arbitrators under the contract. So he has considered everything, sales responsibilities, ITSA, Millard. Kindly come to Millard, page 23 of the judgment, Millard. This is what we have dealt with clause 5.12 of the agreement. Kindly come, my lord, to the last paragraph of that page, page 23 of the trial court judgment. Keeping in view the principles of law laid down in the judgment referred to above, I shall now proceed with the matter. It should be further noted that in instant case, the award came to be passed prior to the October 2015, that is before the amendment, and as such, 34 of 1996 would section 34 of 1996 would apply. Then, following page. As admittedly there is no clause in the agreement or there is any correspondence between the parties with regard to imposition of demurrage upon the petitioner. Under clause 4 of the responsibility of the petitioner's sale is provided, penalty is provided, penalty is considered, whatever there is in the agreement. Right. Then, my lord, kindly take the last paragraph of page 24. Further, the payment of loss of demurrage may not be a ground to reverse or rewrite the tender documents as it was not accepted by the petitioner. Dealing with rewriting the terms of the agreement, the Honorable Supreme Court in Satyanarayan Construction, there is 2011, volume 15, Supreme Court cases 101. This has been quoted there by the learned trial judge. This was a section 34 application, Millard case. Thus, as per the contract, the contractor was to be paid the cutting the earth and sectioning the profile, etc. at rupees 110 per cubic meter. There may be some merit in the contention of Mr. Tandale that the contractor was required to spend huge amount on the rock blasting work, but in our view, once the rate has been fixed in the contract for a particular work, the contractor was not entitled to claim additional amount merely because he is paid, he had to spend more for carrying out such work. The whole exercise undertaken by the arbitrator in determining the rate for work as at serial number 3 of Schedule A was beyond his competence and authority. It was not open to the arbitrator to rewrite the terms of the contract and award the contractor a higher rate for the work for which the rate was already fixed in the contract. The arbitrator, having exceeded his authority and power, High Court cannot be said to have committed any error in upsetting the award passed by the arbitrator with regard to claim number 4. Para 53 was quoted. JG Engineers was quoted again there, my lord. Everything has been well considered by the trial court. I don't think we should go on reading and trouble, but he has not imposed any view. He has considered what is the he liked the majority award. He didn't like minority award. He considered because majority did not consider many important facets. Kindly come to this conclusion. Page 30. The patent illegality is permissible ground for reviewing a domestic award with a ruling on Delhi Airport Metro Express Private Limited versus Delhi Metro Rail Corporation. What would consider patent illegality has been elaborately discussed in Associated Builders, wherein it has been held that patent illegality falls under the head of public policy, failure on the part of the majority tribunal to decide in accordance with the contract governing the parties would be opposed to public policy and awarding claim contract to the terms contrary to the terms of the contract goes to the root of the matter. Ignoring the terms of the contract amounts to gross contravention of Section 28, subsection 3 of the Arbitration Act, and that enjoins the tribunal to take into account the terms of the contract while making the award. To sum up, in the instant case, the majority members of the tribunal have passed an award on 30th August 2015 by directing the petitioner to pay an amount of 19 crore 68 lakhs along with interest at the rate of 8% from the date of the award and 6% from the date of the award till realization, ignoring the terms of the contract and making the award warrants. Invocation of the award vested under Section 34 of the Act. In view of the matter, the award passed by the majority is set aside. The judgment cited by the appellant, with regard where your lordship decided, this is Banerjee there, your lordship said that no, the trial court was not supposed to interfere so much. But that's why your lordship set aside. I'll place that. But here the learned trial judge went strictly what the majority had said, what the minority had said, and why is doing it. Important document has not been taken into account. He has gone beyond the terms of the contract. And you are bound by Section 23. It's very, very clear that it amounts to patent illegality. And moreover, one other thing I must say, I'll place that just now, in regarding that 40 lakhs rupees, the majority just said we're deducting it for the sake of justice. That can't be done in Associated Builders held so. That exactly that point arose. Certain amount was deducted for the sake of justice. Justice Nariman said no, on this ground alone, the award should be set aside. you can be rough and short and anything. You have to go by the terms. What the award says, what the contract says when you're writing the award. But these are so far the trial court. I'll just cite a few judgments. Okay. Because I've given your lordship the. I don't think much has been said about the trial court judgment by the appellant, as far as I can see. But be that as it may, I'll come straight to the. First case that I shall sign will be ONGC versus Saw Pipes. This is reported in 2003, volume 5, SCC 705. This was, my lord, the first case after 1996 Act, which came about, and first case where this patent illegality is also a ground. They wanted to expand the Section 34 application's scope. I'll just place few paragraphs for your lordship's kind consideration.
Figures.
My lord will kindly come to paragraph 3. In the section 34, the word used were public policy of India. Mr. Dave, learned senior counsel, appeared at, this will be at page 713, at the bottom. Appearing on behalf of the respondent company, submitted to the contrary and contended. No, sorry, so I must, may I come to paragraph 1. Sorry. Kindly take paragraph 1, last 4 lines. That is placitum F. Whether the court would have jurisdiction under section 34 to set aside an award passed by the tribunal, which is patently illegal and in contravention of the Act or any other substantive law governing the parties or is against the terms of the contract. Then paragraph 3. Mr. Dave, the learned senior counsel appearing on behalf of the respondent company, submitted to the contrary and contended the court's jurisdiction under section 34 is limited and the award could be set aside mainly on the ground the same is in conflict with public policy of India. According to him, the phrase public policy of India cannot be interpreted to mean that in case of violation of some provision of law, the court can set aside the award. Now they've set out section 34 as it then stood. Kindly take, my lord, Roman 2. This 34(2)(b) Roman 2. The arbitral award is in conflict with the public policy of India. That was, my lord, the language then. Kindly come to paragraph 13 at page 718. The question, therefore, which requires consideration is whether the award could be set aside if the tribunal has not followed the mandatory procedure prescribed in section 24, 28, or section 31, subsection 3.
Where are you reading, Mr. Ghosh?
Paragraph 13, my lord.
1-3.
1-3, page 718.
Yes.
Well, I'm skipping over the others that may not be relevant, my lord.
Yes.
Which F? The question, therefore, which requires consideration is whether the award could be set aside if the arbitral tribunal has not followed the mandatory procedure prescribed on Section 24, 28, or Section 31, subsection 3, which affects the rights of the parties. Under subsection 1A of Section 28, there is mandate to the tribunal to decide the dispute in accordance with the substantive law for the time in force in India. Admittedly, substantive law would include Indian Contract Act, Transfer Property Act, and other laws in force. And then it gives supposing back to kindly come to placitum H, last 4 lines of that page. If it is held, last 4 lines, if it is held that the award could not be interfered, it would be contrary to the basic concept of justice. If the tribunal has not followed the mandatory procedure prescribed under the Act, it would mean that it has acted beyond its jurisdiction, and therefore the award would be patently illegal, which could be set aside under Section 34. For the first time, they introduced, of all the judgments, patently illegal. They are borrowing this term from that famous case of a foreign judgment. Renu Sagar Power Company. Renu Sagar Power Company is patently illegal. From that, they have actually borrowed this. Now, my lord, kindly come to para 15. The result is, if the award is contrary to the substantive provisions of law or the provisions of the Act or against the terms of the contract, it will be patently illegal, which could be interfered with under Section 34. However, such failure of procedure should be patent, affecting the rights of the parties. Then they want to mean what is the public policy, what is the meaning to be ascribed to it. Para 16. The next clause which requires interpretation is clause 2 of subsection 2b of Section 34, which provides that the court may set aside the arbitral award if it is in conflict with public policy. The phrase public policy of India is not defined under that. Hence, the said term is required to be given meaning in context and also considering the purpose of the sections and scheme of the Act. It has been repeatedly stated by various authorities that the expression public policy does not admit precise definition and may vary from generation to generation and from time to time. Hence, the concept public policy is considered to be vague, susceptible to narrow or wider meaning depending upon the context in which it is used. Lacking precedent, the court has to give its meaning in the light and principles underlying the Arbitration Act, Contract Act, and constitutional provisions. Then they go to Central Inland Water Transport Corporation. My lord will now kindly come to para 18 at page 721. Now at the bottom, para 18. Further, in Renu Sagar Power Company versus General Electric, Section 7.1 of Arbitration Protocol and Convention Act 1937, which inter alia provides that a foreign award may not be enforced under the said Act if the court dealing with the case is satisfied that the enforcement of the award would be contrary to public policy. After elaborate discussion, the court arrived at the conclusion that public policy comprehended under 7.1b2 of Foreign Awards Act 1961 is the public policy of India and does not cover the public policy of any other country. For giving meaning to the term public policy, the court observed then Article 5 of the New York Convention of the Foreign Awards do not postulate refusal or recognition and enforcement of foreign award on the ground that is contrary to the law of the country of enforcement and the ground of challenge is confined to recognition and enforcement being contrary to the public policy of the country in which the award is sought to be enforced. There is nothing to indicate the expression public policy of Article 5 of the New York Convention and Section 7 is not used in the same sense in which it was used in Article 1 of the Geneva Convention of 1927 and Section 7 of Protocol and Convention Act 1937. This would mean that public policy has been used in a narrower sense, and in order to attract the bar of public policy, the enforcement of the award must invoke something more than violation of the law of India. Since the Foreign Awards Act is considered with recognition and enforcement of foreign awards, which are governed by the principles of private international law, the expression public policy in Section 7 of the Foreign Awards Act must necessarily be construed in the sense the doctrine of public policy is applied in the field of private international law. Applying the said criteria, it must be held that enforcement of foreign award would be refused on the ground that it is contrary to public policy if such enforcement would be contrary to 1. Fundamental policy of Indian law, 2. The interest of India, 3. Justice or morality. Then the court finally held that, paragraph 76 of that judgment, keeping in view the aforesaid objects of underlying FERA and the principles governing enforcement of exchange control laws followed in other countries, we are of the view that the provisions contained in FERA have been enacted to safeguard the economic interests of India, and any violation of the said provisions would be contrary to the public policy of India envisaged under Section 7 of the Act. Then, I need not trouble your lordship. Kindly come to paragraph 22. Therefore, the submission of the learned counsel requires to be accepted from the judgments discussed above. It can be held the term public policy of India is required to be interpreted in the context of the jurisdiction of the court where the validity of the award is challenged before it becomes final and executable. The concept of enforcement of the award after it becomes final and is different, and the jurisdiction of the court at that stage could be limited. Similar is the position with regard to the execution of the decree. It is settled law, as well as it is provided in the Code of Civil Procedure. Once a decree has attained finality in the execution proceeding, it may be challenged only on limited ground, as the decree being without jurisdiction or in nullity. But in case where the judgment and decree is challenged before the appellate court or the court exercising revisional jurisdiction, the jurisdiction of such court would be wider. Therefore, in case where the validity of the award is challenged, there is no necessity. This is important, my lord, which the associate builders has considered. There is no necessity for giving a narrower meaning to the term public policy of India. On the contrary, wider meaning is required to be given so that patent illegal award passed by the tribunal could be set aside. This is the important point, my lord. Kindly come to paragraph 31 at page 727. At the bottom. Therefore, in our view, the phrase public policy of India used in section 34 in context is required to be given wider meaning. It can be stated that the concept of public policy connotes some matter which concerns public good and public interest. What is for public good and public interest, or what would be injurious or harmful to the public good or public interest, has varied from time to time. However, the award which is on the face of it patently in violation of statutory provision cannot be said to be in public interest. Such award, judgment, decision is likely to adversely affect the administration of justice. Hence, in our view, In addition to the narrower meaning given to the term public policy, in Renusagar case, it is required to be held. The award could be set aside if it is patently illegal. This is a new concept introduced in this case. It was not there before, my lord. And Justice Nariman, his associate builder, said this judgment has still holding the field. It has never been dissented. And even since then. Then my following page. Sorry. The result would be an award could be set aside if it is contrary to fundamental policy of Indian law, the interest of India, justice or morality, then comes. In addition, if it is patently illegal. In addition. Illegality must go to the root of the matter. And if the illegality is of trivial nature, it cannot be held. The award is against public policy. Our award could also be set aside if it is so unfair and unreasonable that it shocks the conscience of the court. Such award is opposed to public policy and is required to be adjudged void. I don't. Kindly come to page 732, paragraph 42. Further, in arbitration proceedings,
Yes, Mr. Ghosh.
Yes. Well, kindly see the conclusion of the Honorable Apex Court, paragraph 74. In the result, it is held that the court can set aside the arbitral award under section 34(2) of the Act if the party making the application furnishes proof that the party was under incapacity. I'm not going to, kindly 34(2). The court may set aside 34(2) may set aside the award 1A if the composition of the tribunal was not in accordance with the agreement of the parties. B. Failing such agreement, the composition of the tribunal is not in accordance with Part 1 of the Act. Roman 2. If the arbitral procedure is not in accordance with the agreement of the parties, or failing such agreement, the arbitral procedure was not in accordance with Part 1 of the Act. However, exception for setting aside the award on the ground of composition of arbitral tribunal or illegality of the arbitral procedure is that the agreement should not be in conflict with the provision of Part 1 of the Act from which parties cannot derogate. C. If the award passed by the tribunal is in contravention of the provision of the Act or any other substantive law governing the parties or against the terms of the contract, the award could be set aside if it is against public policy of India, that is to say, if it is contrary to fundamental policy of Indian law, interest of India, justice or morality, if it is patently illegal. It could be challenged as provided under section 13(5) or section 16(6). And then I didn't know this nothing to do with it. This patently illegality comes in there. This is the conclusion of Supreme Court. Now I shall place before your Lordship I'm relying upon judgment reported in 2015, Volume 3, SSC 49, Associated Builders versus Delhi Development Authority. I shall must come straight to Paris 17 to 9 to 20, 21. Kindly come to Paris 17, Miller, at page 67.
Yes.
It will be seen that none of the grounds contained in subsection 2A of section 34 deals with the merits of the decision rendered by an arbitral award. It is only when you come to the award being in conflict with public policy of India that the merits of the arbitral award are to be looked into under certain specified circumstances. In Renusagar Power versus General Electric, foreign hours so and so, the enforcement then the quoting, then they quoted that. Then you come to the para 19 on the following page. When it came to construe the provision of expression public policy of India contained in section 34 in ONGC versus saw pipes, the para 31 has been quoted, which I read out to your lordship. That in addition, if it is patently illegal, it can be, they have quoted it with approval. Kindly take para 20. The judgment in ONGC versus saw pipes has been consistently followed till date. Then 21. In Hindustan Zinc versus French coal carbonization, this court held in para 14. The High Court did not have the benefit of the principles laid down in saw pipes and it proceeded on the assumption that the award cannot be interfered with even if it is contrary to the terms of the contract. It went to the extent of holding the contract terms cannot be looked into for examining the correctness of the award. This court in saw pipes has made it clear that it is open to the court to consider whether the award is against specific terms of the contract and if so interfere with it on the ground that it is patently illegal and opposed to public policy of India. Then they considered McDermott's case, which is another lengthy judgment. Then, my lord, I can come to para 24. In DDA versus R.S. Sharma, the court summarized the law thus. In para 21, from the above decisions, the following principles emerge. A. an award which is contrary to substantive provisions of law or provisions of the Arbitration and Conciliation Act or against the terms of the respective contract or patently illegal or prejudicial to the rights of the parties. This is also another thing, prejudicial to the rights of the parties. Is open to interference by the court under Section 34(2). The award could be set aside if it is contrary to the fundamental policy of India or the interests of India or justice or morality. The award could also be set aside if it is so unfair and unreasonable that it shocks the conscience of the court. D. If it is open to the court to consider whether the award is against specific terms of contract, and if so, interfere with it on the ground it is patently illegal and opposed to the public policy of India. With these principles and statutory provisions, particularly Section 34(2) of the Act, let us consider whether the arbitrator, as well as the division bench of the High Court, were justified in granting the award in respect of claim number 1 and additional claim numbers 1 to 3. The claimant of the claimant or the appellant DDA has made out a case for setting aside the award in respect of those claims with reference to the terms of the agreement and duly executed by the parties. Then Justice Nariman considered para 25 JG engineers. Para 26, he considers Colonel LSN Murthy's case, fundamental policy. Then kindly take the Lord. He talks about in para 28, he talks about the learned judge about ONGC versus Western Greco International, which is another very important case. Now kindly take this paragraph 28. Kindly take following page 74. Para 38 has been quoted. Equally important and indeed the fundamental policy of Indian law is the principle that the court, as also quasi-judicial authority, must, while determining the rights and obligations of the parties before it, do so in accordance with the principles of natural justice. Besides the celebrated Audi Alteram Partem rule, one of the facets of the principles of natural justice is that the court and the authority deciding the matter must apply its mind to the attendant facts and circumstances while taking a view one way or the other. Non-application of mind is the defect that is fatal to any adjudication. That's what I said to your lordship regarding not considering certain documents at all. Total non-application of mind by them. Application of mind is best determined by the disclosure of mind, and disclosure of mind is done by recording the reasons in support of the decision which the court or authority is taking. The requirement that an adjudicatory authority must apply its mind in that view so deeply embedded in our jurisprudence that it can be described as a fundamental policy of Indian law. Para 39 has been quoted. No less important is the principle now recognized as a salutary juristic or fundamental in administrative law, that a decision which is perverse or so irrational that no reasonable person could have arrived at the same will not be sustained in a court of law. Perversity or irrationality of decisions is tested in a touchstone of Westbury principle of reasonableness. Decisions that fall short of the standards reasonableness are required open to challenge in a court of law, often in writ jurisdiction of the superior court, but no less in statutory processes wherever the same is available. The 40. It is neither necessary nor proper for us to attempt to exhaustive enumeration of what would constitute the fundamental policy of law, nor is it possible to place the expression in the straitjacket of a definition. I need that to be. Then, my lord, 31. Kindly take paragraph 31. That is at page, well, following page. Page 75. Middle of the page. Third juristic principle is that a decision which is perverse or so irrational that no reasonable person would have arrived at the same is important and requires some degree of explanation. It is settled law that where the finding is based on no evidence or an arbitral tribunal takes into account something irrelevant to the decision which it arrives at or ignores vital evidence in arriving at its decision, such decision would necessarily be perverse. This is all that I showed you when I was examining the majority award. So far, the judicial review, the review meeting is concerned under clause 8 of the agreement. So far as the chart is concerned, didn't consider it at all. And Justice Mehra went on extensively showing what is there. Thirdly, that which I shall get here has been dealt with. They went on dealing with 5 times they gave these the demerits claim. 5 times. They totally jettisoned their statement of claim. And Justice Mehra gave the dates even. And eventually, the majority said, we shall do a justice, substantive justice by deleting 40 lakhs, which can't be done. I'll show you just Lordship just now. Kindly come to paragraph 42 at page 81. In the 1996 Act, this principle is substituted by patent illegality principle, which in turn contains 3 subheads. 42.1a, contravention of the substantive law of India, which result in death knell of the arbitral award. This must be understood in the sense that such illegality must go to the root of the matter and cannot be a trivial nature. Whole throughout, I showed you, Lordship, all through Major Port Trust Act, TAM, notifications, all through. Particularly with respect to clause 5.12. This again is really a contravention of section 28(1)(a) of the Act, which reads as under. See, to set out section 28. Then 42.2. A contravention of the Arbitration Act itself would be regarded as a patent illegality. For example, if an arbitrator gives no reasons for an award in contravention of section 31, subsection 3, such award will be liable to be set aside. Same thing. Why did it deduct 40 lakhs? No reason given. Equally, the third subhead of patent illegality is really a contravention of section 28(3), which reads as under. In all cases, the tribunal shall decide in accordance with the terms of the contract and shall take into account the usage of trade applicable to the transaction. The clause contravention must be understood with a caveat. An arbitral tribunal must decide in accordance with the terms of the contract. But if the arbitrator construes the term of the contract in a reasonable manner, it will not mean that the award can be set aside on this ground. Construction of the terms of the contract is primarily for an arbitrator to decide, unless the arbitrator construes the contract in such a way that it cannot be said to be something that no fair-minded or reasonable person could do. then discusses McDermott. It goes on with same point. They came more to the effects of that case.
Mr. Ghosh, learned senior counsel representing the respondent, resumes his argument but does not conclude. Paragraph. Let the matter retain its position in the list.
Millet, Millet, only confine, Millet. I am appearing in CR CLP 7, Millet. I believe, Millet, in that petition, Millet, that a detailed affidavit was filed by the respondent number and by the contender number 8, Millet, and a point of maintainability was raised whether the information that were forwarded to the bench is really within the realm of Section 15 of the Contempt of Courts Act, Millet. That was argued, Millet. I will, Millet, only restrict myself, Millet, with regard to why it is maintainable, Millet. And, Millet, only most of the judgments have been cited, Millet. Mr. Sengupta has also cited a few judgments, Millet. I will only cite a couple of very old judgments, Millet, and two fairly new ones, Millet, and I will close my submissions, Millet. Millet, what I, Millet, understood, Millet, factually, Millet, we are not in dispute that what exactly transpired on the fateful day, Millet, and issues that preceded that, Millet. Lordship, there were, Millet, clips of YouTube snippets that were being handed over with the information affidavit, Millet, where, Millet, the whole issue started sometime during February, when the contender number 8, Millet, in a press conference, stated certain facts, Millet, certain things, Millet, with regard to, Millet, certain members of the bench, Millet, and, Millet, he rallied, Millet, a procession which was coming to High Court, which was, Millet, intercepted somewhere around the Red Road area, Millet, and those are all in public domain. When Mr. Lahiri, Millet, will, Millet, address your Lordships, Millet, the affidavit filed by the Incorporated Law Society, that paragraph has been detailed, enumerated in detail, Millet. I will not touch that, Millet. Mr. Lahiri will address on that aspect, Millet. So, Millet, this, what I'm trying to, Millet, what Mr. Sengupta, Millet, senior friend, Millet, on the last occasion argued, Millet, I will only join issue with the limited extent that, Millet, simpliciter, an act of contempt does not have to be, Millet, the person on that given day has to be present at that given point of time and then saying something which is basically questioning, pointing a finger towards the majesty of this institution, Millet. It is, Millet, the intent and the underlying malice that is, Millet, what is to be looked into, Millet. The underlying malice. If I say something, Millet, we, Millet, also, Millet, being members of the profession, Millet, we sometimes, Millet, are dissatisfied with many orders, Millet. We go out of the court and say, "Dur, buzde pallo na," things like that. It's very normal, but something saying where a direct aspersion is casted upon a member of the bench, Millet, there, Millet, that slight hint of malice, if not a profound hint of malice, that has to be looked into, Millet. And from the very inception, if I say, Millet, I usually do not use expressions that are, Millet, French in nature, Millet. Somebody as gutter mouth, Millet, can only spit venom, Millet. That is all I can say, Millet. Omuk judges sange, Omuk council danale, this, Millet, creates a kind of, Millet, the sense of insecurity towards, Millet, the society. A person, a layman who comes to the court with a lot of hope, with a lot of aspiration that this is the last bastion of our democracy. When his right or her right is, Millet, affected, this is the place where they can fall back to and sees a responsible member quote unquote, of a responsible political party, again, quote unquote, says something which really, shakens the true conscience of a common man. I'm not, whether this institution is magnanimous, this institution is so huge. It has such a lion's heart. This institution is a living being, it is able to take numerous amount of shocks, which it has taken over a period of 150, 160 years, But this institution is made of people, people of flesh, people of blood, people of conscience. Whoever walks into this institution, a litigant, a counsel, a member of the bar, a member of the bench, equally, the responsibility is equally divided amongst all of them, Nobody, can take this institution for granted, And when something is spoken like this, the root of the conscience is hurt, That is what has happened, So it is not a stray incident that one fine day, a bunch of people, comes in the precinct of the High Court, waves a flag or waves a photograph of a sitting member of the bench, stomps the picture, hurls abuses, surrounds a particular chamber of a group of lawyers, takes them to ransom. It is not an incident of one day. It is a fallout of a concentrated effort to derail the judicial mechanism. This is where I join issues with Mr. Shengupta, So far as the maintainability point is concerned, and may I say this with humility, if my institution is attacked, if my house is attacked, for example, and there is a specific procedure laid out in a statute that if your house is attacked by a group of goons with fire and if they are trying to create an arson, you first have to intimate the police that there is a possibility of an arson. If the police say that, okay, we can't come, then you can. But it's my house, it's my institution. If something is hurled at me, it is my responsibility to turn around and hurl it back to them. Who throws a stone gets it back. So no, with regard to formalities, whether Section 15 consent of the Advocate General is really necessary, at the end of the day, the Honorable Advocate General is also a member of the bar, I believe, the limited understanding of knowledge and conscience, that even if this incident was reported to the Advocate General, I'm sure, the Advocate General wouldn't have said that, no, you can't do anything. Because if he would have said that, I do not know, Mr. Basu is not here, Mr. Dotto is also not here, but I can assure your Lordship, little that I've understood the profession over a period of 25 years, a brief period, no person with a conscience and prudent mind would stand out there and say, nobody, no prudent man would have said that. None, zilch. So far as this formality part is concerned, why this is maintainable, I will cite two judgments, and the power of Article 215, encompasses, which has an overriding effect, it is the Constitution itself gives the High Court and the Supreme Court powers, to intervene, to take up issues, and mere statutory formalities can be, it's just a formality. It's it is a mere formality, my lord. It does not have to go through that path and that path only, my lord. First, my lord, it's a very old judgment, my lord. At the time, my lord, when there was no constitution of our country, my lord. Very old one, my lord. Indian Appeals, Volume 10, 171, Calcutta. Very, very renowned one, my lord. This is, my lord, Justice Mr. Surendranath Banerjee. This is, my lord, again, is the judgment of 1878, my lord, 9 years, 7 years before, 10 years before Mr. Banerjee became the fourth Congress president. Congress was established. This is during the Bharat Sabha time, my lord. Justice Norris, Lordship would recollect, my lord. The issue was, my lord, Justice Norris, while with regard to, my lord, some charitable endowment matter, my lord, ordered the Shalgram Shila to be brought into the present of the High Court, my lord. This is that judgment, my lord. I will only quote, place, my lord, 2 pages of this judgment, my lord, page 177 and 179 of this judgment, my lord. This is, my lord, Surendranath Banerjee versus Chief Justice and the Judges of the High Court of Bengal. Reported, my lord, in 10 Indian Appeals, page 171, my lord. I will place, my lord. Why I'm placing this, my lord? Because even at the time when there was really no constitution of our country, when we were not independent, even then, the courts were empowered, and there was an English penal code, but there was no strict sense of contempt act during that time. But the essence to protect the majesty of the institution fell from this judgment, my lord. May I place 2 paragraphs, my lord, of this judgment, my lord?
You don't have copies?
I'm sorry, my lord. Can I hand over a device?
Apply photocopies later.
I can hand over.
No, it's all right. Read it out.
Read out.
ওরে রাখিস না, আমি 5 বার করে বলা সত্ত্বেও না তোরা করিস না।
Yes.
I'm extremely sorry, my lord. The other ones are here, my lord. This is, my lord, at page 177, my lord. The Penal Code for British India was referred to by the learned counsel for the petitioner. In particular, Chapter 11, Section 228 and Chapter 21 of defamation. But that code merely defines the several offenses thereby created and provides the punishments to which offenders are to be liable. It does not at all affect the procedure by which offenders are to be brought to punishment. It is only by the Code of Criminal Procedure read in conjunction with the Penal Code that the jurisdiction of the High Court to commit for contempt was, if at all, affected. Section 228 of the Penal Code, which was referred to in the argument, does not apply to the present case. It relates merely to insult or interpretation to a public servant while sitting in a stage of a judicial proceeding. It does not provide against a contempt of court committed by the publication of a libel out of the court when the court is not sitting. Chapter 21 of defamation does not define contempt of court or make any provision for punishment of a contempt of court by the publication of libel reflecting upon a judge in his judicial capacity or in reference to his conduct in the discharge of his public duties. The offense as a case of defamation might doubtless have been punished under that chapter with simple imprisonment not exceeding 2 years, or with fine, or with both. If the procedure of the Criminal Procedure Code had been adopted, the petitioner had been convicted of simple defamation under chapter 21 of the Penal Code, and after his apology had been sentenced by the court to 2 months imprisonment. There would have been no pretense for an application for special leave to appeal against the conviction. But it is not because the publisher might have been punished for defamation that he could not be punished summarily as for the contempt of court. Lord Hardwicke, in the case of Champion, says, to be sure, Mr. Solicitor General has put it on upon the right footing that notwithstanding this should be a libel, yet unless it is a contempt of court, I have no cognizance of it. For whether it is a libel against public or private person, the only method to proceed at law. The libel in the present case was clearly a contempt of court. It is contended, however, on the part of the petitioner that by reason of the Criminal Procedure Code 1882, the court could not deal with it as a contempt of court or punish the offender by commitment in a summary manner. Several sections of the code were referred to. Section 198 enacts, amongst other things, that no court shall take cognizance of an offense under chapter 21 of the Indian Penal Code and the chapter of defamation, except upon a complaint made by some person aggrieved by such offense. Complaint is defined in section 4 to mean the allegation made orally or in writing to a magistrate with a view to his taking action. Section 195 enacts that no court shall take cognizance of an offense under section 228 of the Indian Penal Code, that is, the offering insult to a public servant whilst sitting in any stage of a judicial proceeding, when such offense is committed in or in relation to any proceeding in any court, except with the provision, previous sanction, or on the complaint of such court or of some other court to which it is subordinate. It is scarcely possible to suppose that the procedure above pointed out was intended to apply to the case of an insult to or a libel upon a high court, or a libel upon one of the judges thereof, imputing corruption or misconduct or incapacity in the discharge of his public duties, or a libel such as that set out in the petition. Section 480 and the 2 following sections of the Criminal Procedure Code were referred to in the argument in support of the petition, but they do not apply to the case of libel or defamation out of court whilst the court is not sitting, and have no direct bearing on the present case. Now, my lord, I'll skip a couple of paragraphs, my lord. At page 179, my lord, from the third paragraph, my lord, may I read? Their lordships are of opinion that a contempt of a high court by a libel as such as the present, published out of court when the court is not sitting, is not included in the words offenses under the Indian Penal Code, although the contempt may include defamation. Such an offense is something more than mere defamation and is of a different character. It is an offense by which the common law of England is punishable by the High Court in a summary manner by fine or imprisonment of both. That part of the common law of England was introduced in the presidency towns when the late Supreme Courts were respectively established by the Charters of Justice. The High Courts in the presidencies are superior courts of record. Even then, my lord, we speak of Article 215 being the court of records. My lord, during that time, my lord, the charters also, my lord, defined that the High Courts will be a court of record, my lord. The High Courts in the presidencies are superior court of record, and the offense of contempt and the powers of High Court for punishing it are the same there as in this country, not by virtue of the penal code for British India and the code of criminal procedure, but by virtue of common law of England. McDermott versus Judges of British Guinea, that judgment was cited, my lord, referred to, my lord. The words all offenses under any other law in section 5 cannot be intended to include a contempt like the present, for which no provision is made by the code. It is unnecessary, therefore, to consider what is the true construction of the word any special jurisdiction or power conferred by any other law now in force in section 1. The lordships, having decided that the libel was indeed a contempt of court, and that the High Court had jurisdiction to commit the petitioner for a period of 2 months, this case is not a proper for an appeal to Her Majesty, and then appeal got dismissed. Why I am placing this judgment, just to trying to draw an analogy between how the courts during that time used to think when there was nothing written in code, but still the court considered that there is a basic difference between a contempt and a defamation and a libel. A libel which will tantamount to something which will really hit the majesty of the institution will be contempt and not just a defamation, my lord. This distinction was drawn, my lord. This is the distinction which I am also, my lord, trying to, my lord, emphasize. By simplicity, somebody saying that certain councils are very pally with a certain particular judge and certain orders are passed. How these orders are passed, we all know. It's just merely not a defamation, merely not a libel, my lord. It's much more than that, my lord. This is the reason, my lord, I cited this one, my lord. The next one, my lord, I will cite another English judgment, my lord. 1999, Volume 2, Appeal Cases, 294. Copy. Airdrop করে দেবো আমি দাঁড়া একটু airdrop করে দেন না মইনাক Gilbert আনে This is Millard. Gilbert Annie, this is a Privy Council, Millard. Gilbert Annie and others, the directors of public and directors of director of public prosecutions, Millard. This is an appeal which arose out of from the Supreme Court of Mauritius. Which will kindly take page 295, Millard. Second paragraph, Millard, held. She's got that, Millard. May I, Millard?
Yes.
Great. Dismissing the appeal on appeal to the Judicial Committee held dismissing the appeal that since by virtue of separation of powers between legislature, executive and judiciary as entrenched in the Constitution, the primary duty of the judiciary was to maintenance of fair and effective administration of justice. The power to protect that administration against contempts calculated to undermine it was an integral part of the judiciary's constitutional function, and therefore the Supreme Court constituted by Section 76, subsection 1 of the Constitution of 1968 had an inherent power to punish for contempt. That law in the Constitution was not confined to statutory law, but included common law, so that the common law power to punish in contempt had not been abrogated by Section 5 or 12 of the Constitution, and that in any event, Section 15 of the Courts Act, in its original and amended form, gave the Supreme Court statutory power to punish for contempt. Precisely what, Millard, in Prashant Bhushan, also in Pritam Pal and other judgments, Millard, Pritam Pal, I believe, has been already cited by Mr. Sengupta, Millard. I will not trouble your lordship with that, Millard. Prashant Bhushan, he has cited, but I will also cite this one more one I would cite. Pausing here for a moment, Millard. Here, Millard, it is not a mere procedural aspect of Section 15 that has to be followed, Millard. the establishment of a superior court being in a state, the High Court under Article 15 being the Court of Records, and the Supreme Court under Article 129, my lord, they have inherent power. So whether somebody complains, whether somebody does not complain, whether a postcard is written, my lord, whether the judges on their own motion sees an article on a newspaper, watches a television clip, they have the power inherently imbibed in them to haul up anybody who tries to, my lord, mingle with the majesty of this institution, my lord. Precisely that has been done in this present case, my lord. The informants, my lord, merely approached the judicial side of this Honorable High Court, my lord, brought it to the notice of the High Court, whether Section 15 is mandatory or not, absolutely, and does not, my lord, it does not, it is not relevant at all at the given point of time, my lord. I remember, my lord, I'm a movie buff, my lord. One movie, my lord, one dialogue I cannot forget, my lord. A very popular movie, Munna Bhai MBBS, my lord. The patient is brought in and he's almost a dying patient having a seizure. And the authorities standing over there saying, जाके पहले counter में जाके form fill up करो. So this is like counter में जाके form fill up करना है. Section 15 is like going to the counter, filling up the form, and then coming to the court when the court is already been held in ransom by some person trying to act as a responsible citizen and making obnoxious comments about the institution, my lord. Can't be done, my lord. There has to be another way, and this is the other way, my lord. The Constitution has given us the power, my lord. It has given this honorable court the power, my lord. May I, my lord? That although, next paragraph, my lord, two other judgments, my lord, were referred to, my lord, in this, my lord, while quoting the previous paragraphs, my lord, the next paragraph, my lord, that although freedom of expression was guaranteed by Section 12(1) of the Constitution, the offense of scandalizing the court fell within the qualification to that right provided by Section 12(2), since the offense existed solely to protect the administration of justice and was reasonably justifiable in a democratic society, that the offense of scandalizing the court was sui generis and not part of the ordinary criminal law, and the implied requirement of Section 10(4) of the Constitution that any law should be formulated with sufficient precision to enable citizens to regulate the conduct of their to regulate their conduct applied, but that there was no breach of the guarantee of certainty that even though no maximum penalty had at that relevant time has been prescribed for the offense, the range of penalties could be ascertained from the decisions of the Supreme Court. I will skip few lines from there, Millard. Then Millard at page, the next page, Millard, 296, Millard, subparagraph 3, that where publication was intentional, here I say, Millard, and I say with conviction, Millard, every single word uttered by the contender number 8 was intentional, was with absolute highest magnitude of malice involved in it, only to show his political superiority over an institution which we feel is the highest bastion of democracy in the state. And this malice should be nipped in the bud, Millard. That where the publication was intentional and the article was calculated to undermine the authority of the court, and the defense of fair criticism in good faith did not apply. Is it fair criticism? Let I pause here for a moment and say, judges সাথে council setting আছে, can it be a fair criticism? Hell no, can't be. Never ever I have heard such a thing being uttered and can be bypassed by saying this is fair criticism. I have very limited experience in this field, Millard. I'm sure, Millard, my learned friends on the other side of the aisle, friends on this side of the aisle, can enlighten your lordship on this on a better way, Millard, whether this can be a fair criticism. The offense of scandalizing the court was established and no additional elements of mens rea was required to be proved. If somebody says there's nothing else is required, Millard, nothing else at all, nothing at all. And that there was no basis on which the decision of the Supreme Court could be successfully challenged. Decision of the Supreme Court of Mauritius, affirmed, Millard. I will not place it any further, Millard. This is what I wanted to place, Millard. Now, Millard, my second last judgment, Millard. AIR 1981, I'm sorry, Millard, 1981, 1 SCC 436, Millard. This is Millard. This is Sarkaria's judgment, Millard. S.K. Sarkar, Member Board of Revenue, UP Lucknow versus Vinay Chandra Mishra, Millard. 1981, 1 Supreme Court cases, 436.
Which paragraphs, Mr. Ghosh?
I will give you, Lordship, the paragraphs, Millard. Paragraph 8, 10, I'm sorry.
And
15, 17, 18, 19. I'll very briefly, Millard, I will not trouble your lordship.
No, because we have to rise at 4:15 today because of administrative reasons.
I know, Millard, I know. Millard. I will not trouble your lordship. One paragraph, and Prashant Bhushan, I will only rely upon, Millard, the head note and two more paragraphs, Millard. I will try and, Millard. Millard, paragraph 19, Millard. Section. Lordship will kindly take, Millard, the first portion of the head note, Millard, at page 437, Millard. Lordship will find held, and thereafter, Millard, the smaller paragraph and the longish paragraph, Millard. Section starts with section 15 at page 437, Millard. Lordship has got that, Millard?
Yes.
Yeah. Section 15 does not specify the basis or the source of information on which the High Court can act on its own motion. If the High Court acts on information derived from its own sources, such as from a perusal of the records of a subordinate court, or on a reading a report in a newspaper, or hearing a public speech, without there being any reference from the subordinate court or the Advocate General, it can be said to have taken cognizance on its own motion. But if the High Court is directly moved by a petition by a private person feeling aggrieved, not being the Advocate General, the High Court has in such a situation a discretion to refuse to entertain the petition or to take cognizance on its own motion on the basis of the information, or to take cognizance on its own motion. I'm sorry, will it? Yeah. Just a second. I'm sorry, will it's too small for me. Refuse to entertain, Millard, or to take cognizance on its own motion on the basis of the information supplied to it in that petition. If the petitioner is a responsible member of the legal profession, it may act suo motu, more so if the petitioner advocate, as in the instant case, prays that the court should act suo motu, court should act suo motu if the court is prima facie satisfied that the information received by it regarding the commission of the contempt of a subordinate court is not frivolous, and the contempt alleged is not merely technical or trivial, it may in its discretion act suo motu and commence the proceeding against the contemner. However, this mode of taking suo motu cognizance of the contempt of a subordinate court should be restored to sparingly where the contempt concern is of grave or serious nature. Frequent use of that portion, my lord. Advocate General, my lord, this portion, they say, my lord, that it is required, my lord. Now, my lord, Lordship will kindly come to paragraph 17 once, my lord. I'm sorry.
No.
No.
Yes, section 15 is set out in 17.
Yes, yes, my lord. And paragraph 8 is relevant, my lord. Paragraph 8, I will, can I come back on the next day, my lord? I really want to place this one.
After vacation, though. It
Because
can
this
only be after vacation.
Yes, yes, I have no difficulties, my lord.
Mr. Riju Ghoshal, learned senior counsel, representing the informant in number 7.
CRCLP 7, my lord.
CRLCP 7. CRLCP number 7 begins his argument but does not conclude. Paragraph. Since the puja vacations are knocking on the doors, let these matters be listed again immediately after the puja vacation. Bolo pabe. প্রথম বুধবার বুধবার
বুধবার ছুটি না
29th বুধবার
30th
Mark 29th
October
এগুলো নাও
29th September is Shoshti. Sorry, Shoptami.
29th is chuti.
29th is chuti. Chokudan is done by that time, 29th morning.
Vijaya is the second. Vijaya, second.
Sorry?
When is Dashami?
Dashami is 2nd of October, my lord.
2nd.
29th October. Obliged, my lord.